record after our executive session. All members are and we're into the public meeting portion of the agenda. So first item on the agenda is open public comment for non-agenda items. Waiting on the topic, not otherwise on the agenda.
I have no idea what that is.
So they'll indicate it ready. We will move on. Commissioner Butterworth, Jerry Stable, things. Commissioner approve access to our adult minerals down anything else has talk about issues. Nothing was really just an update, but the commission know that the hearing thing with DRS for the final permit or no permit process. There's been media coverage. What has been
and just for the record, they're an active trustee for us. We have a current contract with them, and they're now going through the permitting process.
We have briefly, I was with our neighbor of our down on the Eagle River. Finished to bring on the topic access. All we have access. Very interesting part about that. Access. With them all up. We are on to the Department of Natural Resources Executive Director report.
Good morning, Commissioners. Ginny Brandon, Deputy Director of the Department of Natural Resources. I'm here to give the Executive Director report. I just have a few things. Starting on a little bit of a bleak note, we are experiencing drought conditions throughout the state. We are right now 70% of snowpack. Southern Colorado is much worse, about 50 to 60%. Northern Colorado is a little better at 80 to 85%. Previous runoff was okay, but our reservoirs are looking pretty good. It's hot, and so we're
by transit mix to mine state land board minerals. Conversation fundamentally shifted when the Niobrara oil play kicked. We're seeing mining start to from the
map of the property, and as '80s, and this was from a different operator. And then in 1992, Renegade actually leased this tract of land from the State Land Board, and no production occurred, and so the lease expired in 1997. The current lease that we're going to be discussing today is a 2005 oil and gas lease. This is a more close-up map, and this is the current status that the COGCC shows. So if you were to log on to the COGCC website, this shows here is the 133, and here is the 233 well. So the 133 to the north, I wanted to point out on the legend, you will see that the status is temporarily abandoned. And one of the things we're going to discuss, and that was in your cover sheet, is that this well is actually plugged and abandoned. But today, on the commission's website, it is still showing as temporarily abandoned. And when you talk to them and ask why that is, one reason is because you have to file a form after you plug a well. It's called a subsequent notice of plugging, a Form 6, and that was not filed until December 29th. And so they haven't officially processed the paperwork yet. Once the COGCC approves and finalizes that paperwork, this status will be changed. Second, they told us that the monthly Form 7, it's an activity report. It hasn't been reported yet that it's been plugged and abandoned. So because of these items, it's still showing as temporarily abandoned. So if you were to go on the status on the website today, this is how it shows. So a little bit of background. When Renegade got this lease, they re-entered the 133 well, and it produced from August to September 2012, so August 2011, a little over a year. And at that time, they felt that there was issues, and so they changed the status of the well to shut-in. And so in our oil and gas lease, there's actually a provision that allows a well, if it's shut in, to be held for up to 5 years. And there's a 5-year limit on that shut-in period. And then semantics-wise, how that kind of works internally, once a well goes into shut-in status, our staff, our finance department, would set a reminder in 4 years to send a reminder out to the party to let them know, hey, you're in your 4th year of shut-in, you only have 1 year left. And so that's semantics-wise kind of how it works internally here. It reminds us that they only have a year left and reminds the operator as well.
So really, Commissioner Butterworth, so that would mean that the 5-year period would have expired September 2017, nothing else occurring.
Correct.
That's what that shut-in extension timeframe would be.
Correct. Yeah. And so the COGCC actions I'm going to discuss now, the State Land Board is not a regulatory authority. We don't regulate. The COGCC is who regulates operators. And so concurrently, while we're managing and monitoring our leases, the COGCC is regulating. And so these actions were occurring simultaneously. We don't get copies of notices if they have violations, things like that. Typically, we rely on our lessees to contact us or notify us. Sometimes the COGCC happens to contact us, and that's how we find out. But upon review, in February of 2016, the COGCC sent a warning letter for the 133 saying it needed a mechanical integrity test. And so once a well is shut in, you are supposed to conduct a mechanical integrity test within 2 years. And so this well was shut in 2012. So technically, this letter could have gone out in February of 2014. And for whatever reason, the COGCC, their auditing process, they didn't turnover and staff, I'm not sure, but they didn't get this letter out until 2016 saying that this well needs an MIT, a mechanical integrity test. So this prompted Renegade to change the status of the well to temporarily abandon. And I'll kind of explain a shut-in well. Typically in the field, they say a well that's shut in, you can go and flip a switch. It's a well that's capable of production, but is not. So you could just go flip a switch and turn it on and it would start producing. If a well is temporarily abandoned, that requires more mechanical work. So you'd actually have to go in and fix something. You can't just flip a switch. So that's what the difference is. But what I'm bringing up here is that they didn't actually do the mechanical integrity test. All they did was change the status of the well. And so in 2017, it prompted the COGCC to send another letter again saying we still need that mechanical integrity test, or you have to plug and abandon this well by July 1st, 2017. And at this time, fines could have been issued. I'm not sure why that didn't occur, but the well was ultimately plugged and abandoned. That was the choice that they made instead of doing a mechanical integrity test. So it was plugged and abandoned on June 28th. Something that the State Land Board sent out in this same time period in May of 2017, that reminder popped up in our finance department saying, it's been 4 years, you're in your last year of shut-in. And so our finance department sent out that reminder, letting them know that they had until February 18th. And so that reminder was letting them know if a well is shut in status, you have until February.
Why February?
I think that's the way historically staff did things. They would give them until the anniversary date if a well was in shut-in status. And so
Anniversary date of the
execution
of the lease, not
yes.
the execution of the 5-year extension.
Right. I think the reading of the lease could be that it would expire, but the way things were practiced at the time was if a well was shut in, you would get until the anniversary. So the next issue that I wanted, or the next thing that I wanted to discuss was the meeting on August 1st. And so this is a meeting that was had between staff and Renegade, and it's in your cover sheet, and it's something that I think Renegade's going to discuss as well. But this meeting happened on August 1st, and Renegade contacted us prior to the meeting and said, we'd like to discuss 3 different issues with you. One of them was this lease. 2 of the others are unrelated to this lease entirely. And so at the time of this meeting, Katie and I did do a cursory review because we were, they had called us and kind of laid out what they wanted to talk about. So we were aware, we did a cursory review of the lease, and it was the same website. What the website showed then is the same as it is now. So if like I just showed you, how the well shows that it's temporarily abandoned, when we logged on to the COGCC website at the time, it still was showing as temporarily abandoned. We did not know it was plugged and abandoned. We thought that the well was still considered in shut-in status. And so in this meeting, we discussed that we would not be extending the shut-in period, and they would be allowed just the expiration that is normally allowed for the shut-in period to that next anniversary date. And so that's the letter that came out afterwards that is in your packet.
And shut-in status, they have until February 17th to produce.
Yes,
So if
to
they're
either
producing,
produce
then-
that well,
yeah.
or have a well, some sort of well capable of production on it. So, yeah, flip the switch or
Yeah.
get something else. So the next well that I'd like to talk about is the 233. Right here you can see it's a star, and that on the legend shows drilling. So the one thing I'd like to point out here is that on the website today, this is showing drilling status. However, that is due to paperwork that Renegade filed after our notice of default. They filed this paperwork in January of 2018, so 2 months ago. Prior to that date, this well has always been listed as plugged and abandoned. Anytime, the reason this is important is because anytime staff would pull up the website, look to see what's going on, we had no idea that operations were being conducted on the 233. So Steve Fries, our field tech, didn't have it on his list to go inspect. He often goes and inspects wells that are being worked on a lot. He was unaware that there was operations going on. We were unaware. And so that we didn't really know about the 233 until all of this paperwork was filed. So that's one point I want to point out. So as I discussed, we found out later, it was actually Katie was on the phone. Our oil and gas specialist, Katie Stitt, was on the phone with the COGCC talking about the plugging of the 133 well on December 21st. And at that point, they asked, can you guys give us an update on all of the operations going on the 233? They don't have a valid permit, and we see that they're working out there. And so that was the first we had heard about that. We didn't have any information to give the COGCC, but it did prompt us to realize we really need to look into this lease because we're not sure what's going on. We were unaware of the plugging of the 133, and now we didn't really realize that the 233 was being worked on. So this is what prompted staff to send out a notice of default and gave them 30 days to cure. And Renegade did respond to that notice of default in January. So our notice of default, their response, all of that information was included in your packet, and it's very technical. So I didn't know if anyone had any questions at this time. I'm happy to go over anything with you. Okay, I'm seeing none, so I'm gonna.
Well, Crystal, did the actions taken by Renegade cure the default by the 29th of January?
Well, so when we did get information from them, and some of it was very technical. And so staff wanted to take a further, first we asked for more substantiation and support because we were unclear on whether or not it cured it. But the definition in our lease is that it has to cure it to staff's or to the state land board satisfaction. And at that time, we didn't think that it cured things. And so we asked for more additional documentation at that time. So we asked, the reason we asked, as I said, they provided information to the COGCC on the 233 well showing that it had been drilling from 2011 until now. So 6 or 7 years.
How long does a drilling usually take on a well?
Usually about 30 to 60 days to drill and complete a well. And so when we saw that there had been 7 years, it did trigger in our minds, okay, that seems like a very long time. We would like substantiation because the COGCC doesn't require any proof or substantiation. So we asked for rig tickets, which will show the work that was being conducted. And so when they sent in all of that extra information, staff really took it seriously and wanted to go to extra steps to review the information. And I'll talk about like some of the other parties that we hired and looked into. So there's only, there's just 2 main points that are talked about a lot in the cover sheet I thought I'd try to address with you. First is the shut-in status. So the way staff reads the lease is that if there is a well that is shut in, that would trigger the shut-in provision, and that allows you to hold the lease up to 5 years. As soon as a well is plugged and abandoned, it's no longer shut in, so you're no longer allowed to use that shut-in provision. Then you have to look what other terms in the lease can save this lease, or is there another savings clause? And so that's when we sent out the first notice of default. We had seen that there was the 133. We found out it was plugged. At that time, we had no idea that the 233 was being drilled. So we thought there was no well capable of production. This lease is terminated. So we sent out the notice of default. Then they got back to us and said, wait a minute, there's the 233 and we've been continuously operating on it. And that's when we looked into all of the supporting documents we requested, the rig tickets, and we took a look at the whole lease. And so we looked at the drilling over the last 7 years and the rig tickets. We discussed this issue with the Attorney General's office, and we also realized that we needed to hire a special assistant attorney general who specializes in oil and gas lease interpretation and rig ticket. She has more background on rig ticket review. So we went that route. We also talked with this issue with the independent petroleum engineer, and we wanted to make sure that we did a thorough investigation of if we felt that this was considered continuous operations and if we felt that they were working bona fide and diligently. And I think when we looked at the totality of the circumstances and said, this is a 2005 lease, we are now 13 years later, we felt that there was a failure to perform. And so ultimately we did terminate the lease. So if you guys have any questions, I'm happy to answer
What was the
them.
effective date of termination?
The effective date of termination, I believe, I'm not sure if it is at the actual,
At the end of the shut-in, like?
I don't know if it's like the
February?
notice of default or
Okay.
if it would be like the date we send the default letter was December 29th, or the date we terminated was like February 12th, I believe.
Katie Stitt, oil and gas specialist. I terminated this lease effective February 14th, which was the date of the termination letter.
Okay. That is the termination.
Other questions for staff at this point?
Okay, I'll invite Renegade up.
Yes, please.
Okay. My name is Ed Ingve. Last name is Ingve. I am owner operator of Renegade Oil and Gas Company. I've been operating in the state of Colorado now for in excess of 30 years, including on state land board property for in excess of 30 years. One of my first wells is actually on the Lowry Range that I was involved in. We've worked in the past with the state land board very closely. We've got multiple state land board leases, not just on the Lowry Range, but in other places. In fact, historically, I know we've worked with even Tim Kelly back there and Mark Davis and everybody. We were developers of the Totem Gas Storage Project. I don't know if anybody knows any of that or not, but we actually worked with the land board to develop gas storage leases for the first time that they had seen and things of that nature when we went back in Mark Davis's era. Anyway, to go to the story. I think it sounds like, and I think I'm getting affirmation of that the situation with regard to the lease termination, at least from the land board perspective, happened at the plugging of the State 133 well, it appears. If that's not the exact case, then I'm welcome to hear, but I think that's what we've heard from staff. As a result of that plugging, we were concerned about the lease status, and we wanted to schedule a meeting with the land board and staff to let them know what our plans were at that time and what else was going on out there. I will take significant, I know in the discussion of that meeting that we had on October 1st, or August 1st, excuse me, that we disclosed that the State 133 was plugged. And that was our primary purpose for the meeting is we wanted to try to get an assurance that what we still had cooking was still going to work for now. And, I've got supporting documentation. I'm going to have you flip around a bunch of times here, but when we get to that point, but that was the purpose of our meeting, at least the meeting that we requested on August 1st, at least in our minds. There were some secondary issues too that we were hoping and looking for help on and such, but that was our number one agenda item. We knew that plugging of that well put us a little bit in a precarious situation. We had submitted or tendered a shut-in payment for that year. We had been given at that point in time at least an assurance that we're good through the end of the lease term, which was this February 17th date. And we disclosed at that time that we were working on this other well with intention of hoping to get it back on production, reestablish production from it. It was a previously plugged well from the 80s also, and that we would be diligently trying to complete those operations so that could happen. The other thing that we did have going on at the particular time is there was an agreement with another company that we had made, Highlands Natural Resources, which indicated to us through a farm out arrangement that we had made with them that they were going to be drilling a well. They had till October 1st to commence that well. It was specifically laid out in an agreement, but that's probably too much for the weeds that we need to talk about right now. So anyway, we disclosed the fact that yes, the well was plugged, and that we were working on this other well, and that we were just trying to get some sort of assurance, not only for ourselves but also for Highlands at that time, that that the lease was still in reasonable status and that we could proceed. I think well, I'll show those documents in a bit, but that we got that assurance from that meeting, both verbally and written, after we were done. But whether they say that he said, she said type of thing, I recognize that potentially that could go contentious. But just for backing up purposes, I would like to call your attention to Exhibit 10 of ours, which is document 150.
Sitting with that Ingvi is JB Condil, CFO and Vice President of Land of Renegade Oil and Gas. Ed's pointing to page 150 of 160 in your packet.
And this would have been under the State Land Board. No, this was under our exhibits, excuse me. Exhibit 10 is all of Renegade's exhibits. And this would actually be page 19 of our exhibits, I think is how it's done, isn't it? Yeah. If you notice, that is a field inspection form filled out by the Oil and Gas Commission. The Oil and Gas Commission oftentimes will sit a P&A job, especially if it's in an area that they deem maybe a little bit more environmentally critical, and just make sure that the plugging is done in a proper manner. And from the first page of that inspection form, well, the inspector on location was Susan Sherman. She prepared this report 2 days after the plugging was finished. And if you look at the contact information, you'll see that Steve Freeze of the State Land Board was noticed and emailed on her inspection report, showing or giving notice that the Land Board did have notice of the P&A. I also believe Steve Freeze was at our meeting when we met with staff on August 1st. So anyway, I just want to call that to your attention that even if there's a recall issue or something like that going on, there was notice through this inspection report that the Land Board had that the well was plugged within a few days of when the actual plugging occurred. Secondarily, I know we went in and there again, I don't know how much weeds we get into, but Renegade had been working with Diana Byrne of the Oil and Gas Commission. A lot of this things as to whether it was shut-in status, TA'd status, a lot of that was directed by her. She knew that we were having a lot of difficulties with the well. The well we had got into production back in 2012, and I was trying to stimulate the well, and I had a contractor drop tubing down the well, which resulted in a fishing operation, and it punctured the casing, and we were trying to extract that tubing back out and trying to reestablish production. So all along, Renegade thought we had a well capable of producing. It's very common that well, from a production reporting standpoint, and JB can point that out, if you've got a well that you cannot report monthly production on, the commission would deem it shut in. Or I guess you could change the status to temporarily
If you
abandoned.
did not produce oil or sell gas, you are not allowed to put PR in the status of the well producing. Then your options are shut in or TA. And when the tubing was dropped down the hole, the well became shut in. It wasn't producing. We immediately began trying to fix the well to reestablish production, and shut in at that time was proper. As time passed and we were unable to repair the well, with continuing efforts, discussions with the Oil and Gas Commission changed that status to TA.
That was at the request of Diana Byrne. She was saying, well, this well really isn't shut in. I'd probably characterize it at this point as a temporarily abandoned well. We said, fine, we'll change all that stuff. It doesn't really matter from the MIT requirement perspective at this point in time. There are different MIT requirements for shut-in wells or temporarily abandoned wells. But in this case, my well had exceeded that length of time. I think it's a 2 year for one and 5 year for the other. Or no, 6 months for one and two years for the other. So in either case, an MIT was required, and I was talking with Oil and Gas Commission staff saying, it's not going to test. I can tell you that already. We got a hole in the casing. We're trying to fix it. We're trying to fish pipe out. We had been on this well, I can't remember how long, but years. And there were a few breaks here and there. When we tried to regather ourselves, we changed type of equipment that we used. We moved in well, I guess that's the 233. We, there were operations that we thought we were getting close, and then we changed horses as far as how to do it. It became an extremely complex type of job. And I was trying to work with the Oil and Gas Commission saying, man, I really want to try to reestablish production on this well. What do I need to do here? And she kind of sat on some of the information because she knew that it wasn't going to TA. So a request for it wasn't going to MIT. So a request for an MIT, we all knew wasn't going to do any good. I sent her, she requested, and that is in your packet, 33, page 33 of, well, you got it Exhibit 7, but I don't think it's Exhibit 7, is it?
33 of 160.
Of
That's the
160.
easiest way to find it.
I filed this at the request of Diana Byrne, and there is reference in there as to what was happening with regard to the pipe dropping, and also discussion about how I would still like to salvage the well. Part of the reason I was so stubborn in trying to get this well back on is I knew in its current situation, it would compromise horizontal well development. The commission has policies in place saying that if you're going to drill a horizontal well and there's abandoned wells in the vicinity, you have to be able to demonstrate that they're adequately cemented and that they've been adequately plugged, or else they will not let you complete certain intervals within a certain designated footage of that previous well. And part of this would harm at least a couple potential horizontal wells in the development pattern that we had kind of envisioned that might be in place down the road. So I was trying to be stubborn. I mean, if I was smart, I should have probably just said, let's plug it as simple as we can from whatever we can get from the Oil and Gas Commission and move on. But I was A, trying to reestablish production, and B, trying to protect the future horizontal development in this particular area. I believe on this well, there was also an insurance deal because we did get in an argument with the contractor as to whose fault it was. We picked up $1 million of his insurance to try to repair the well. I think in total, we've probably spent in excess of $2.25 million on this well to try to repair on the 133.
When we get to the 233, another $1.5 million or $2 million
to try to fix that one. So anyway, there again, I would dispute the fact that the staff was not noticed. I believe there was nothing in that August 1st meeting that would why would we? I mean, it was an obviously provable fact that the well had been plugged. I don't think we would have not disclosed that. Whether they were relying on the Oil and Gas Commission website too heavily at that point, I don't know. But I know it was discussed in our meeting. So anyway, and I think we've got backup that at least Steve Freeze with the State Land Board had been noticed. So anyway, that's kind of where we go with that. To dispute some of the 133 facts. Hang on, let me flip. Okay. Well, first of all, one of the things that we'd want to do, and I think Crystal even indicated that for years and years, the acceptance of a shut-in royalty payment generally carried you through the lease anniversary date, which in this case was February 17th of 2018. We were, even prior to our meeting, if you go to exhibit or page 19, which is exhibit 3, and this might have been that auto response letter that Crystal was referring to, saying that we have noticed that the well has been temporarily abandoned since September 2012. It's the State Land Board's policy to only allow the lease to be held in for a shut-in for 5 years. And please contact us or the lease will be terminated the next anniversary date, February 17, 2018. That was even prior to our meeting. That was a May 8th letter. That was by Rodney Jones. Then subsequent to that, and if we go to page 20 and 21, pages 20, 21 of your exhibit, in your packet, which is from exhibit 4. This is what came as a result of the meeting that we held with staff on August 1st. And I'd just like to highlight a few things there. The the first few sentences, I think, go a long way to explaining things. Thank you for the meeting with the land board on August 1st. Per the meeting, Renegade Oil and Gas is concerned about three issues. State Land Board has reviewed the information and provided a response below. And then the highlights of the response below. Per prior correspondence written to you and Highlands Resources, the State Land Board is willing to extend the lease until the next expiration date, February 17th, 2018. This lease will be terminated on February 17, 2018, and unless it is held by some other provision as defined in the lease, and it quotes the lease number. So we certainly felt that at least at that point in time that we had reasonable assurance through February 17th that we were good and that we could proceed either with completing our development or completing our operations on the 233 if we could get there, or protecting a potential farm out deal that we had with Highlands Natural Resources, because they had indicated at that point in time that they were going to drill a horizontal well on the lease. Either one of those should have accomplished holding the lease, at least in our minds, and we really had extension granted through this reasonable assurance till February 17th. If we didn't have that, if we weren't granted that, I would have approached things differently. I probably would have immediately gone into some permitting mode. I would have tried, some other things going on, but I guess I felt we had enough within these letters and enough with staff discussion that we were granted until February 17th of this year to get something going out there. We spent, since that decision, probably in the neighborhood of about $125,000. Approximately maybe half of that was on additional operations on the 233, trying to get that well back resolved again. And probably about half of that amount would have been toward permitting a new well, a 333 well, which Renegade chose to start and initiate in October when we saw that Highlands was failing to live up to their end of their farm out agreement. The 233, I'll talk about that well just a little bit. That was another very complicated situation. Both of these wells were complicated because they were previously producing. So that it's not like a new drill well. You're not using necessarily your traditional drilling equipment. We're using production pulling units out there as opposed to drilling rigs, although we did move a drilling rig over to the 233, another long story. But the casing in both of these wells had been shot off, so there was no way from surface to be able to attach down to the pre-existing casing that was set in the 80s. So we had to wash the well down, wash the open hole down, and try to come up with a plan to reattach to the old 5.5 casing. I've done that in many places. Usually it's not that hard. In these particular two instances, it's been extremely difficult. And we've run into all sorts of problems, including another contractor dropping pipe and things of that nature. So there was a lot of things that complicated this tremendously. But once again, the 233 was in the same position as the 133. There was no bond log present to show that the Niobrara formation was adequately cemented. So once again, for horizontal development activity, this area of the section would not be allowed to be completed in the Niobrara because of, I know what the restrictions that the Oil and Gas Commission would put on there. So I was there once again, stubborn again, saying, well, if worst case scenario, we need to, even if we don't get the well productive, we at least need to demonstrate that cementing is good so it doesn't interfere with a future Niobrara development plan. So that was part of the reason there. Since the plugging of the 133, I can assure you there were no gaps more than 60 days of work that was not performed on the 233. What the current operation that we were involved in is we were trying to run a camera for a third time down the well. The first couple times we ran a camera down the well to try to see where to grab pipe and find things that were dropped in the well. The mud in the well prevented clarity for us to be able to see what was going on down there. So we were trying to circulate as much fresh water as we could to try to see if we couldn't clean up and improve the visibility. We're adding flocculant and things of that nature to try to coagulate the mud and have it fall to bottom. So hopefully we could see what was going on there with a camera. We had tried twice before, and both times we did not get the pictures that we were looking for. So that was what we generally were involved in from, say, not entirely, but from about the time that the 133 was plugged until I think we abandoned this toward the end of November. Once, and at that time we kind of refocused and repivoted our emphasis in trying to get this 333 well permitted and done, since we knew we were on the clock. The permitting process typically and now has become very laborsome, and it's almost a 4-month process to get a permit anymore, it seems like, when you get it through all the agencies. I think the rig tickets that we provided would have indicated how difficult the operations were. And we definitely made an offer to the staff at that point in time that if it's not going to be something that somebody who, unless they're very familiar and want to spend a lot of time, would be able to get up to speed on quickly. I know the documents, it took me personally 8 hours just to copy them. So we're not looking at a situation where I don't think somebody could do a cursory review of this and know what was going on. So I indicated that I'd like to make myself available to help them out. I never got a call on that. You know, I've been doing this for 35 years. I'm a petroleum engineer. I've done several of these reentry works. A lot of people kind of lean on me when they're doing this type of work. And I'm very, very comfortable saying if the petroleum engineer who was reviewing this would have consulted with me, he would have deemed what I was doing as a wholly reasonable plan. There's no way he could have developed a handle on the current condition of the well. It's not his fault. The documents that he was looking at, it looked like, were the P&A reports predominantly, and then records predominantly since June of this year, not knowing what happened in the previous 5 years and where we were at. You can just even see from his report, it doesn't make sense given where the well's at and what its status is and what's going on there. But then one of the things that I kind of called to my attention here a little bit ago as I was reviewing for this proceeding, our lease was actually terminated on February 14th, 3 days before it would have terminated by its own expiration anyway. I'd like to call your attention to page 126 and 127, which is their expert report. Our report, like I said, our lease was terminated February 14th. I'm sure because the Attorney General and things were involved, it was probably drafted at least a day or two before that and circulated. If you'll note, the petroleum engineering expert report was submitted Saturday, February 17th, and not actually submitted to staff until February 20th. So his report was submitted after our lease was terminated. So I think the indication that there was reliance on his report to assist or to conclude that this lease should have been terminated doesn't stand up. The decision as to what contemplated bona fide operations, I think, was already made. I don't know by whom in the staff, but I believe it was by the staff, and it certainly doesn't appear that they were relying on the expert given the dates. So anyway, I obviously would object to that an expert certified that we weren't doing diligent operations. Let's see. I say outside of the years that were performed on these leases, I referred to this farm out agreement, which we entered into Highlands Natural Resources. That was in July of 2016. Part of the purpose of entering into that agreement was to give Highlands a very limited right to drill a single horizontal well in this particular section, and that would help us evaluate. At that time, this was a pretty significant step out from other horizontal well activity in the area, and we were trying to look for a proving well. Renegade was. And we said, okay, and they were after some other sections of ours too, but we said, okay, if you're going to drill there, you need to drill a well down here for us also and help us prove up the value of this particular area. That agreement, they have, on Highland's request, was amended several times. The date slipped. I know that has nothing to do with the land board. They requested extensions. And they didn't start drilling on October 1st. Now, the reason that we chose on the last extension is October 1st is we felt that gave us enough time to go out and permit a well if necessary, if they didn't perform. So that gave us approximately 4.5 months, which we thought we could get the permitting done within. When we did
pursue
start,
that,
excuse me?
did you pursue that?
Absolutely. That was the $65,000 in permitting.
Did you receive the permit?
We had everything, but the only reason it was halted is because the land board said, we don't have surface owner's permission. The Arapahoe County people told us we were good. The Oil and Gas Commission told us, people said we were good, but they were it was lacking state land board consent.
What was the timing of that? January, February? When?
The permit officially was submitted. We were in dialogue and the drafting and everything that has to occur. I think we submitted stuff.
Page 155 out of 160 is Renegade's notice letter to the land board dated October 4th of 2017, 3 days after Highlands did not drill their October 1st well, informing them of our desire to drill a vertical well.
We had talked with permitting personnel and things of that nature even prior to that.
Page 158 is a plat of survey, but it shows that on October 12th, Renegade, the land board, and the surveyors agreed on a location for that well. Permitting continued from that point forward. December 29th, the notice of default was issued. Arapahoe County and the Oil and Gas Commission were informed by the land board to not approve the permits in process pending the outcome. Towards the end of January, Renegade was informed by both Arapahoe County and the Oil and Gas Commission that the permits were ready to be issued pending okay from the land board.
Like I said, the first indication that we got from the land board that there was going to be an issue in extending this was on 4/47 on the Friday before New Year's weekend, December 29th. That was the first communication that we had from land board staff and that was a letter that was drafted to us asking us to cure 4 default areas, if I remember right, or 4 provisions of
notice of default letter, yes.
And up until that point in time, we had been talking with land board representatives. We had on-location visits with Steve Freeze. We had discussions about the road. We had discussions about a couple water wells that were out there. And all this is necessary in your permitting now in oil and gas. You got to have everything down pat before you submit it for completeness. And like I said, we didn't find out until later that there was actually, I believe, some sort of communication between land board staff and at least Arapahoe County, telling them, because one of the things that Arapahoe County is going to say is, hey, are you guys good with this as surface owner? And then the indication at that point in time was, no, we're not. So they processed the permit up to that point in time, and we were waiting for final permitting. We thought that we would cure the defaults and they would issue the permit anyway. We'd still get rushing out there. I had trucks, I had drill contractors, I had everything lined up to get this well kicked off within the time frame necessary. And part of it, quite frankly, was because the other well just was frustrating, complicated, and I saw the drilling of a new well as being the solution to bringing clarity to the lease being held. So that was my objective and my goal, especially when Highlands did not perform. Now we've subsequently have gotten in issues with Highlands, and part of it is because of their non-performance. They were supposed to perform and prevent me from having to go out and drill a new well. So there's also a part that they were trying to force into acquiring all my rights with regard to this section, when I gave them a very limited single well right. So we've had spacing arguments with Highlands. We've had pooling arguments with Highlands. Highlands has been trying to skirt the process and trying to get a well drilled, and not now just a well, but they want to drill an 8-well pad between this section and the adjoining section that Conoco gave them some rights on. even though there's no gas sales out there and other things, but they were trying to come up with a way to make this a bigger deal than what my deal with them was initially, and basically backdoor confiscate my acreage in accomplishing that. So obviously things got very contentious with me and Highlands. One of the things, though, that we do know that was going on during this process, because we did make a CORA request, is we know Highlands and State Land Board were negotiating for surface. And the surface was going to be located on our particular lease. So we were not necessarily thrilled about that. We didn't know what our rights were necessarily there as to whether we could prevent them from doing that or not, since now the acreage had been spaced together in a 2-section unit. But we have become aware that standard land board practices is they will not allow a non-consenting party or party not involved in the lease locate their surface site on a state land board issued lease without that lessee's consent. So in this particular case, I believe it was somewhere about the same time our lease termination or default letter was sent. Crystal had called us as to whether we would agree to Highlands placing a site on our lease, and we said no. We thought it was a fairly easy way for us to prevent what they were trying to backdoor and do to us and many other issues here. So we didn't agree to that, but through this CORA request and the negotiation of the surface lease, we've had a few things that have kind of come to light that has troubled us, to say the least. First of all, well, Highlands always asked that, hey, we can't get a hold of Renegade. They can't, they're not answering their phone or something. We adamantly disagree with that. We were never called by Highlands. They knew that things had gone contentious at that point in time, and they knew they weren't going to get approval. We had previously said, because of things the way they broke down, we said, well, we can't do anything with Highlands verbally anymore. It has to be written. If you want to talk with us, send us something written on paper, so at least we have back it up, because they have been kind of fast and loose with verbal representations before that. So there was no communications between us and Highlands, even though they made representations, I guess, to State Land Board staff that they had been trying to get a hold of us. So yeah, we went to the CORA request. We were interested to see what was going on there. This stuff is not included in your packet. We didn't get the CORA request back until packet preparation was done. But we can tell, and there was back and forth emails between Crystal and an Eric Anderson of Highlands, who is their land guy. And a couple things that disturb us. This was toward, well, it was November 21st. In some of the CORA stuff on emails that we've obtained, we've got one from Crystal to Eric. She was concerned that the farm out agreement wasn't valid either anymore. Highlands was wrongfully representing that the farm out agreement was still alive with regard to drilling on these sections. We would contend absolutely that it is not. So that's why they were trying to skirt around us as much as anything. But yeah, here's a November 21st email. They're hoping to come up, or this is from Crystal to Eric. We are hoping to come up with a solution. And I guess my question is what's the problem? Then I got a response back from Eric to Crystal saying, thank you for working us to help us find a solution. And I only can speculate that solution that they were looking for is trying to get surface ownership or surface permission somehow, some way from Renegade, or maybe changing board policy, I don't know, to be able to cite something out that particular lease. Then there was some additional communication that we saw December 21st, which also referenced a meeting which was held on December 20th. That December 21st, Highlands actually presented the State Land Board with an indemnity agreement in case Renegade ever sued them to hold them harmless. So obviously they were contriving some sort of way to cite this pad on Renegade's leasehold at the time. I question the timing of this all, and then in particular, this was December 20th and 21st, and then this default letter shows up on December 29th. I have a hard time buying that. You know, only when Highlands entered the picture and asserted rights that they may or may not have, and kind of had a whispering campaign in the land board's ear that maybe their plans were superior to whatever Renegade was trying to do, did they kind of adopt a aggressive way of terminating this lease, which was completely out of line from past policies. I guess I asked you on the email that I'm seeing, is that the solution that they were working on? I don't know. It just seems awfully coincidental that Highlands and the land board were talking about a solution to a problem that Highlands had, and then all of a sudden we get lease termination stuff. It seemed awful unfair to begin with. First of all, like I said, we were going through the permitting process. We had made land board people out on location. They knew what our plans were. That all of a sudden this lease gets this level of scrutiny 51 days before it would have gone away anyway if we didn't perform. It was actually terminated 3 days before the end of the lease. It just seems like there was things that were accelerated and compressed to make sure Renegade didn't have a way to continue holding this lease by a viable means. Yeah, I don't know. That's probably the basic of my presentation. I don't know if you have.
Just filling in one last date and then we'll be done. The lease termination notice was February 14th. The deadline for nominations of parcels for the upcoming May auction was February 15th. And this particular parcel was nominated at 5:05 p.m. on
which probably brings you to say, well, was Highlands ever going to drill the well that they had promised me that they were going to drill? I think they have been contemplating a way to secure the rights without my cooperation.
And so Ed will take questions now or later, or Crystal, or thank you very much.
Have the lease reinserted, what is your going forward strategy? How do we have any kind of comfort that?
Well, my going forward strategy would try to immediately revive all the permitting that we had done for the previous 333 well and get a well into production, you know, as soon as practical. The location that we picked, while it's a vertical well, it would be for a legacy D&J sand reservoir. We've actually analyzed it with seismic because a lot of the seismic has been shot out there for the Niobrara, and it actually looks like a pretty suitable location for D&J production. We've already got the facilities and the gas tie-in so that we can immediately go producing this well. That is the concern right now with the horizontal drilling of the Niobrara is the people that we've talked to and the people that are getting ready to build the midstream operations and the pipelines into the area are telling us they're probably still at least a year away before they'll be in the area to collect gas. And you could not do horizontal Niobrara development and sell gas. So the gas would have to be vented and flared, which is what Highlands is doing on the other pad site right now. And I know they were chastised in front of the commission last month about that, and we're supposed to give them an update to the Oil and Gas Commission about, okay, what are you going to do about this flaring gas? But it would be immediately to try to get a vertical D&J well into production. I believe now we've also been told that our permitting and things has to almost start all over again now. So I would imagine we're looking at a 90 to a 120 day type of time range, I think, to get a well initiated out there and hopefully completed, 30 days after that. It would be a new drill, though. Would be my plan, at least at this point in time, and kind of waiting on the midstream for the Niobrara development to come.
Thank you.
Just a point of clarification. Did you say the 333 would be a new well, or I thought earlier you had said that it was an existing well that you try and reconnect?
No, the 333 would be a brand new well. In fact, I don't know if that map is there. I could show you where we picked the location and we're having the permitting for it. But it actually is between two wells. We drilled wells on the section to the north and the section to the west out there. Renegade also possesses those leases 5 years ago, 6 years ago.
2009 and 2011. The 333 is planned to be right in the center of what Crystal showed you.
Yeah, it would be in the northwest of that section, right there. And there was productive wells. Obviously, the 133 was productive. We drilled the most southern well in the section above it, and the well to the west in section 32 was drilled by us, and there was a previously producing well, another bird state well in the northeast of 32 that actually we got other washdown operations going on that will complicate things even further, so I don't even want to comment on that.
It's a fine D&J vertical well location.
Correct, and it would allow us to analyze it also for Niobrara development, which is what we did on that 32 well. We actually secured when we drilled that well at that time, the Niobrara was just starting to ramp up. We actually secured an entire core in the well that we drilled on that vertical well up there of the entire Niobrara section, which is being coveted by a lot of people for analysis and things of that nature for the Niobrara development in the area. And the core looks fine. It looks like there's every reason to expect that this would be a fine area for horizontal Niobrara drilling.
Other questions?
I guess I have one on the 133, you had it in the shut-in clause, so you knew you had 5 years. So then on the 233, you were trying to get it ready because you knew you were coming up on your 5 years, or?
We were trying to fix both, and Diana said, finally, she said, well, you got to give me a P&A, Diana Byrne of the Oil and Gas Commission. She said, you got to give me at least a P&A request for that well, because I'm under pressure here that you're going to have to do an MIT or something, and I don't know how long I can keep this in this fluid status that it was in. And we were trying to fix the well, and she knew that, and we were working with her. But once the 130, and she gave me that deadline of June 1st, saying I don't think I can go past that. So if you get it fixed by then, or we're going to have to plug it, and that's July 1st, and that's what we proceeded to do. I requested that we get one more opportunity to try to fix it. It's still going to need to be re-entered again if and when Niobrara development comes, or a radius around that well is not going to be allowed to be produced in the Niobrara formation. So it was twofold. It was A, to get the well back on, and B, to protect the development down the road.
And if I can supplement, the 133 was a reentry in 2011. A successful reentry in production was established. The 233 isn't just a recent well. It was the reentry of it began in June of 2011, and it was a failure. I mean, it was just terrible. But work went on to try to repair the failures that happened through it, and it ended up, or is now, probably something that will be plugged and have this Niobrara issue. But it wasn't, the 233 didn't start when the 133 went away. They were concurrent. One was successful, one was not.
The 133 was a successful washdown. We were able to get and retie to the casing relatively easy. I mean, it took a month or two, but we did get that one all buttoned up, and we had it as a productive well. It wasn't until the contractor dropped the pipe down the well that well suddenly got very, very complicated, and it was in production for over a year.
So yeah, I think you're estimating it was 233 was in production.
No.
It was never successful.
Not by Renegade. It was back in the 80s.
Okay.
His previous comment was 133.
Right.
Yes.
Yeah.
And it's my belief back in the 80s that the wells were prematurely plugged, and I thought there was additional zones that could have been recompleted into them also, but that was late 80s in a depressed oil market also. So
When did your planning start with Highland to drill this third well when you knew, I mean, when was that? When was it?
Highlands has no part of the 333 well, you mean?
But they did, right? They
were going to be drilling a vertical well, or excuse me, I'm sorry. A horizontal well along the very southern edge of my section was what I granted them rights to.
Okay.
Just one. And I was somewhat relieved, thinking, okay, well, if we're still having problems on the 233, at least I'll have a producing well down there. and we won't have this kind of foggy lease issue out there. It'll hold it. And we gave them till October 1st. Well, initially it was supposed to be done a
October
year
1st.
and a half ago, and
October 1st.
we kept granting them extensions and extensions, but October 1st was the last time frame we gave them to.
Do you guys have leases on other non-state land board parcels?
Yes, I mean, on the
third parties, BLM.
Yes. Renegade owns about 100 and almost 200 wells.
And out of curiosity, I mean, I can see how the confusion could occur, but do your other lessors permit notice to the COGCC to be noticed to them under their leases?
I would say there's under our fee leases, there's very few things that we'd even talk to our lessee about or notice them about. There wouldn't be a, I mean, they're getting a royalty check and that's all
The lessors don't scrutinize like state or the BLM would.
Okay, but does the BLM permit COGCC notice to substitute for notice to the BLM under a lease?
We have one BLM lease and they own 5 million acres and 640 acres. I think the answer is no, but I don't have that experience.
Okay. Thank you. No further questions. I'm assuming staff might want to have it noted.
A rebuttal. Or
Do you wish to?
Get Crystal a chair.
Crystal Cranda, Minerals Director. I just wanted to maybe make a note about the Highlands argument. And I know that there was some discussion on whether they influenced our decision or not. And I just wanted to put on the record that Highlands had absolutely no influence or determination on this, on the lease termination. The entire time we've been working with Highlands and they've been requesting a surface use agreement. We did not have Renegade's approval. We never granted them one. Highlands was giving us a rosier picture that they were still working with you guys. You guys were doing great. They were going to get your approval any day now. And so that's some of the emails when it looked like, hopefully we can get something worked out. It was under the assumption that they were going to get approval from you. At no time did they ever influence our review of the actual lease terms. So I just wanted to put that on the record. Yeah, they never were approved for a surface use agreement. And I just wanted to put that on the record.
While you're here, and I apologize for going back in the weeds, but I'm trying to get date consistency. There was a February 17th, 2018 memo from Dan Hall to somebody who subsequently transmitted it to you on the 20th, which was 6 days after this. Did you get an oral report from those folks prior to receiving the written report?
Yes, we had been speaking with the Assistant Attorney General, and she had been in contact with Dan. So there were a lot of oral communications about the review of the rig ticket. We didn't actually get a formal report. If you saw, it was just an email, and it was kind of something that said, hey, do you want me to put this in writing? And we thought, sure, it'd probably be good to have this information in writing, but there were oral conversations had prior about the information. So.
Commissioner, why did we move to terminate on the 14th instead of letting the lease expire on the 17th? Because could we have let the lease expire? It's my understanding they were no longer in compliance.
Yeah, I think we wanted to
shut-in.
make it clear that this was terminating due to a failure to perform and not because of an expiration, and that, and I think we just wanted to make that clear.
And had they, just with the 333 well, had they permitted that and drilled that, had we granted them access, would that have kept the lease? Would that have been enough to extend the lease? Is that considered?
Yes, it would have been. And I mean, we never, I know that was brought up. We never were not granting them access. We had approved their surface location. It was through, they hadn't been issued permits through the permitting agencies. So.
questions?
Yeah,
please go.
one for whoever wants to take this, but Mr. Engley, what I think I heard you say was we should have known that you had plugged the 133 because you filed a form with the OGCC. And yet in our August 7th letter, we wrote to you describing that it was shut in, and you never corrected that. You said you had plugged it in June and we should have known, but I think we're telling you in August 7th. So in my book, sorry, it's page 20 of
Yeah, I didn't have them
160.
tabbed that way, so
Yeah.
let me see here.
Yeah, and it was in your documents as well. I apologize.
Right.
But it's our letter to you all in which you read almost all of the relevant paragraph, but you skipped the part that said it was discussed that the lease has been held by a well that has been shut in for 5 years. We told you what we thought our opinion of the status was, and you never corrected us, yet you knew you plugged it in June.
Perhaps you could say that. I guess I thought that we were convincing with our 233 argument, coupled with the fact that we had submitted a shut-in payment. If you notice on the Rodney Jones letter, in particular, he uses shut-in and temporarily abandoned interchangeably. So I guess I was kind of thinking, well, it doesn't really matter which well it is. We're good till February 17th.
I think another question I had too is that if you had said, you had given yourself 4 months to drill the 333 and permitting can take 4 months. I mean, if there's a 60-day continuous, cessation clause, I didn't know how that would match.
Well, we worked on the 233, I think, up to Thanksgiving.
I think our last rig ticket.
We submit the last one you submitted to the engineer I saw, but I came back and we found ones that weren't paid yet, and those were referenced, I know, in documents that you had. They are. I don't know if you want to try to look for that or not.
It just seems if it's a 4-month process, that would be over the 60-day timeline too. So.
Well, at that point in time, I guess we didn't think that we had to continue necessarily with the 60-day ongoing, and we were, like I said, we're a small shop and we were focusing on this permitting stuff and trying to get that done as fast as we could. We had till, I think we moved the rig off and November 20th is when we moved the rig off. In fact, I even went over there and pulled tubing on it again very recently. I don't know if it would have been within the 60-day clock or not, but once we got the default letter, it was like, oh, what are we even going to do there? Because my going forward, operationally there is completely different as to whether we have a lease or not. If we don't have a lease, I'm going to plug it and get out of there as fast as I can. If we've got a lease, my mindset was still, we need to fix it if possible, and certainly try to at least, check the box as far as the NIBURA issues that would be encountered with it if we ever did future NIBURA development there with the cementing, demonstrating adequate cementing across the NIBURA. So, I don't know, I guess I thought we had reasonable assurance, like I said, that we had till February 17th. We had it on multiple letters and correspondence that I just thought that we were good to the 17th and that the permitting could be taken place and we'll get the well drilling. And then guess what? Then I don't have to come in here and talk to you about how I think it's still being held because of this clause or that clause. It would be kind of an open and shut case with a new well.
I guess a question I have is if we wouldn't have, on the expiration date was the 17th, but then the expiration date for the May auction is the 15th. Is that correct? So if we would have let it expire to the 17th, would we have been able to enter it into the May auction?
Well, just so you know, that track has been removed. It's not going to be in the May auction anyway. So staff does a thorough review of every track prior to putting something on the auction. So it's been removed anyway. But your point, no, it would have been past the deadline. Sometimes it's a deadline to get stuff in. I mean, sometimes we work with operators and allow it to come in a week late if we haven't reviewed it yet and let it come in. So I'm not sure. It just kind of depends on if we only have 3 nominations and someone brings something in a couple days late, we usually allow it. So.
Commissioner Greg Okish, Assistant Director, I think the pertinent point is parties are free to nominate anything they want, anytime they want. We can't control that. The fact that Highlands chose to nominate was at their discretion. It's not our obligation to accept that, and we have not. So nominations happen, then staff has to review them and decide what will go forward to auction, and this tract will not go forward to auction.
All right, why don't we, if there's any further questions of staff or Renegade?
Yeah, can you talk maybe a little bit more? I mean, this seems to be focused then on the notice of termination, and we issue that notice of default, identify our concerns, 30 days to cure those. They respond, they feel like they cured our notifications. We determine it did not satisfy. Can you talk about our concerns or why their cures were not up to our standard?
I think there's a lot. I mean, a lot of it was discussed in executive session. I think there's issues with the addendum clause and the 60 days of continuous operations and whether there was a cessation of 60 days. And I think that if rig ticket, I mean, even if they're admitting that operations stopped in November, from November to the end of the lease in February, that's a greater period than 60 days. I also think there's an argument about that was kind of more discussed previously about whether there should be an allowance or an ability to even drill a 333 when there is nothing capable of production on the lease at that time. There's a lot of different legal arguments that were looked at. There was just the totality of circumstances, the development in the area, different horizontal drilling that had taken place, and whether or not we felt that this was developed up to the standard of the field, which is required in the lease. So there was a lot of different factors that were looked at when we decided that what they provided was not sufficient. And if you have more legal questions about that too, we can.
And I guess I just would like to reiterate too, that once we got the default letter, we didn't know what to do with it, you know, at that point in time. And that was about 30 days since we worked on the well last. Like I said, we were trying to get a camera ready, but there would be no reason to do that if we didn't have a lease. So, I mean, the reason that we suspended operations at that point in time is because we were trying to figure out what our point forward looked like with that particular well. And like I said, we thought we had permitting going on. We thought we had reasonable assurance that we had till February 17th to get something going. I was, you know, this ground and this acreage, obviously, you guys know, is extremely valuable now. I think the land board has seen that too with some of their recent auctions. We are very aware of that. We are getting calls on it all the time on people wanting to do deals out there. I think it's premature. I think they're wanting in, getting in a little early. We're kind of waiting it out to see what happens, especially with the midstream development. So, I mean, if we knew there was a problem out there, we would have come up with a way to hopefully satisfy the situation. Where we, by no means did we ever envision that this lease would be, you know, yanked away from us, and we would have done anything and everything that we saw fit to try to preserve it and protect it. So I guess communications that we had, I know, and I talked to Crystal, I think when we first got the default letter, I said, well, where's this coming from? And I think she had indicated that, well, there was some uncomfortableness between you and Highlands and things, and the Highlands things kind of stirred things all up, and we just wanted to go back and look at it and see if we thought that this was a valid lease or not. And I just, like I said, it kind of came out of the blue when we got it. I think he maybe gave me a heads up on a phone call or something, but I think it was maybe that day or that morning. And it was kind of like, oh, geez, well, okay, now what are we going to do? It was holidays and things of that nature too. We had just dumped a fresh load of flocculant in that well, which, again, trying to get the mud, getting the floating suspended particles out of the fluid and try to get them to coagulate up, and then they fall to bottom. And that's what the last operational thing is what we've done on the well to try to accomplish prepping it for a camera run.
So Crystal, were you aware of the contentious relations between Highlands and
Sort of. We knew something was going on because they weren't. We thought Highlands was going to drill, like the same situation happened in the north on section 15 inside the Lowry Ranch, and everything worked fine between the parties. Highlands drilled the horizontal wells, got the surface use agreements approved by Renegade. It all went kind of smoothly. So I had assumed that this process would be the same, and it wasn't, that we weren't getting approvals. But when we talked to Highlands, they would constantly tell us that they were working with Renegade. So I wasn't sure the amount or level of contention. No.
Tiny bit of history. Oh.
The 1516 to the north was not the same situation. We ended up selling them our Niobrara rights. And so we didn't have an objection. We couldn't object.
Right.
This was a farm out. So,
well,
Introduce yourself.
for the record,
JB Condell, Renegade Oil and Gas.
This is Ed with Renegade. Just for the record, just a tiny bit of history and clarity. We cooperated with Highlands on the perceived farm out wells that they permitted. There was this one, and then there was one on the adjacent section, and we cooperated with the land board in giving them surface access for those 2 wells, one of which would have been on this particular section. And that was what we had contemplated. But immediately after we give them that permission, Highlands parlayed that into a spacing application for the entire section and turned around and then ended up dropping these particular wells and permitting 8 wells, an 8-well pad. They also hit me up with a $56 million funding request for my share of those wells, and in essence, in a way to try to extract my rights and acreage from them, or from me. And obviously at that point in time, the relationship with Highlands got strained through the late summer, early fall.
Sorry.
Go
Go
ahead.
ahead, John. Go ahead, Commissioner.
Commissioner Shaw, it seems to me simplistically that there's a 3-day differential that we're discussing right now, whether it's the 14th or the 17th. And I don't understand how you could, if you'd have had the benefit of that additional 3 days, you could have qualified for an ongoing lease.
I'm going to represent to you, that things changed on December 29th. We had heard from the parties at Arapahoe County that the land board was not saying that the lease was valid at that point in time, that it was under question, under review. So they stopped processing their permit. We did not have a permit. Our permit was not approved. We did talk to them, and that was the last item on their checklist to actually give us a permit. In fact, we had even gone out there early February in anticipation that everything was going to be all cleared up. And I think we did $10,000 or $15,000 of road improvements and things like that in anticipation that that was all going to be requirements within this Arapahoe County permit. We knew what was in the permit. We knew what was coming and what our requirements were. And we wanted to improve roads and things like that we could, and do everything we could prior to actually having the permit, so that we had as much or as minimal to do as soon as we had the permit to go. But like I said, I had trucks, I had rigs, I had everything all ready for this well. We were anticipating about a February 10th start on this going, but we did not have a permit. So we did not have approval to be able to get in there and do anything. The permit was because of state land board actions.
Okay, 2 questions, Commissioner Butterworth here. First, Mr. Ingby indicated he's a lessee on the old other state land board leases. Have we ever had any issues, concerns with
this
performance?
In terms of payment, no. They've been audited in our normal auditing process, and they've been a normal payer. In terms of filing compliance with the COGCC and some of those things, I think we're looking into a lot of those other leases. There might be compliance issues in terms of, COGCC filing.
Sure.
Things of that nature.
I do have 2 other questions. So then second question, Can just clarify this? I'm hearing from Renegade that State Land Board is communicated with Arapahoe County saying, don't do anything with this permit. You said, no, we've never had those conversations. What's
So
that's important to me.
I was
in
emailed
some
by
respect.
Arapahoe County and the COGCC, and they ask us, is the lease in good standing? And so at that time, we were issuing notices of default. And so I said, it is not. As soon as we, if this is cured, we will let you know immediately. So we never asked them to withhold a permit. I don't know what their process is. I didn't know if that would stop the permit. All I did was respond to the status of the lease.
Mr. Ingby, what's your desired outcome?
I'd love the opportunity to get back out there and drill a well and hold my lease. Like I said, we've obviously sought legal advice through this period. Most of the legal advice that we've obtained says that, in essence, from that December 29th notice date, that in essence the lease should have been told at that point in time if it is reinstated, and that we get those days back. I don't know if that's enough to get it re-permitted or not at this point in time. I'm hoping it can be. That would give us, today's March 15th, so that would give us almost 2.5 months. I don't know if I can get expedited permit that quickly. The Oil and Gas Commission also screwed up, but that was another sidelight. They actually canceled the permit as opposed to suspend the permit. The people down in the permitting office in the Oil and Gas Commission said, yeah, that was our mistake. We shouldn't have done that. But now, because we did that, we're going to ask you to go through the whole permitting process again if we need to. They should have put it on hold, and she acknowledges that. And Jane Stansfield is somebody you can contact with regard to that and such. I don't know what would happen now when we re-permit to the Arapahoe County people, if they're going to deem this a whole new permit, or whether we're going to have to, a lot of the stuff is in place, and we know what now is acceptable, but there's still a lot of notice periods and things like that might not be, we might not be able to expedite. I would hope that maybe we can get it a little bit faster than maybe the first permitting acquisition that we did, but I don't know that. And I have not talked to drilling contractors and things too. That's going to be the next issue is I don't know if I can get that window back, or whether I'm going to be a little bit at their scheduling mercy.
I think some of the challenge on our end is, we want to get our assets in production and we want to be generating revenue. And I think I'm hearing your perspective, and there's an element that I'm empathetic to. At the same time, it's like 17 years or not 17 years, 12 years, 13 years, and only 1 year of production. I mean, I understand you've articulated how $2 million on 133, $2 million on 233, but why so long to get consistent production?
Well, like I said, I've been stubborn because I didn't want to necessarily plug those wells and re-drill them. You don't know how many people have said, well, why don't you just re-drill this thing? And I said, well, there's implications with regard to Niobrara development down the road, and that would harm the ultimate development there as far as what the final well and horizontal development could be. This area, though, is still, the Highlands wells are the closest to development here. Those were just drilled last October and have just only recently been put into production, but they're still struggling with the fact that they don't have gas sales. The closest Conoco wells that are in production, I believe, to this particular lease is at least 5 miles away, I'm going to say. So this is not, adjacent development acreage ready to go in there, and that's largely because of the limited gas sales situation out there. And I think I think Katie said she was listening to the Oil and Gas Commission hearing last month, and the commission has expressed significant concerns about development occurring out here and just venting the gas. And I would think you all, as trying to optimize your value of your leases and leasehold and royalties, also would be very concerned about that too, because right now there is not an option. So you can drill the wells, but you're gonna be losing 10 to 20% of your value right off the top by not having a applicable gas sales outlet. So I think I think things are coming down here. Conoco obviously developed their own midstream company and their own pipelines. They had the size and the synergy to make that happen. But they haven't even come down this far. I mean, there's Conoco leases dotting all over the place out here, and they haven't developed any of those with horizontal activity yet either. This is way down the list on their priorities in this particular area. They're concentrating on the north end of their leasehold and the west end. This is south and east. So like I said, development's coming, but it's on the Niobrara side, but it's not coming that fast. The legacy stuff, that's why I leased this stuff to begin with, and then I released it later is because I saw a DSAN channel through this particular area. That's, I'm a legacy old D&J player before Niobrara was even a glim in anybody's eye. And I thought this particular lease had potential for that. And that's why I secured the leases way back when. Obviously, D&J vertical stuff has kind of become passe with investors and with everybody else out there nowadays. But I'm still old school enough to say, okay, let's go out and drill a vertical well because I think it still can make some money.
Greg, were you trying to, anything? Any other questions? And just make sure we get a clean record. Is there any public comment on this file? Seeing none, we'll close public comment. Further deliberations to the board.
Crystal, how often do we issue default notices and how often do they end in termination?
This is my first termination, and I mean, I've only been minerals director for a year now, so this would be my first default notice as well.
I guess maybe Greg or Bill, any sort of, I don't recall.
Gokish assistant director. I'm not intimately involved in the day-to-day operations, but I don't recall any actually in the 5 or 6 years I've been here. I'm sure there's probably been a couple, but I don't recall them.
Just to weigh in on I guess how I'm reading the situation, and Mr. Rainbay, I in my day job, because this is not a day job, I contract with the government, and oftentimes I find myself not in complete compliance with the terms of my government contract, and I can tell you that as a matter of course, I become a part of their equipment. I am oversharing aggressively to make sure that there's no implication of anything except extreme good faith when that happens. And I see here a pattern of questionable adherence to the lease terms, including several defaults, and what I would not characterize as extreme good faith in managing the contract in those situations, and it ultimately resulted per the contract in what I think is fair to describe as an imperfect cure, as the cure is described in the contract. So I'm not sure what way if we're going to get a motion, what way that's going to go. I am comfortable supporting staff in this termination because of that. I being a government contractor can be a real problem, but boy, I tell you, when I've got an economic interest in the contract, I try really hard to make sure that nobody can accuse me of ever doing anything but acting in extremely good faith. So that said, any other thoughts on this issue or motion?
Yeah, Commissioner Moffett, I'd ask you sort of, I mean, I'm clearly not articulate right now. I guess I'm not detecting extreme bad.
No,
faith.
I just no. That was not my application.
Detecting that this is like gross negligence, or that there was something really malicious intent. And I'm just like swept. I mean, I'm not operating in this day to day. It's just like a bunch of like, well, should we have been more clear? Should I like lots of, and I don't disagree. Like I'm all about. I mean, he's the lessee. They have an obligation to
and an economic
interest to be a strong partner. But that's why I also asked. Like he holds other leases, and we don't have a history, and it's not now even clear. You know, I know we're doing research to see if there have been violations or notices from
There's
the
been a lot of
OGCC.
inspection.
What's
like,
that?
I mean, there's, in terms of inspection violations, I mean, like with Steve Freeze, our field inspector. So, I mean, there has been issues, but typically they do resolve them.
Yeah.
Crystal, how many oil and gas leases do we have?
About 1,500.
Okay, Commissioner, I was going to, if it helps for context, I think the board operates in a manner like we do with our grazing lessees and like we do with a lot of our other lessees, that we don't have the resources to continually, regularly, you know, frequently audit every lease and make sure they're in compliance. And I think this is an example of what can happen. I think when staff did come to our attention that there might be lease compliance issues, and we did investigate, and we did find, I think, a series of things that were concerning: the lack of filings, the those kinds of things. So where was I going? I'm mimicking your inarticulateness. I think your point was partially how much of this, you know, should we own? And I think we can own some of it, but we are not in a position where we are looking at how the operator's working on these things every day. And when this one did come to our attention, I think we found a number of concerns with it, and that's where we are today.
Just on some of the paperwork type things, I work very closely with Diana Byrne. She will attest to that. Some of the reasons why some of that paperwork wasn't filed until more recently is she is so overwhelmed down there. She doesn't want to see a preliminary report. She goes, I won't even approve those. I just ignore those. So here we had ongoing operations. We hadn't reached the completion of the well. So in some respects, there was no reason to file anything because she wasn't even going to get around to reviewing it, even if it was kind of an interim process situation. So the changing from shut-in to TNA and things of that nature, if it was drilling, tell me when it's done kind of thing is the attitude now. I don't think she envisioned either, and I'll be the first to admit it, that I think she maybe had a 4-month, 6-month type time frame in mind, not necessarily a 5-year time frame in mind. But she has told me that in the past, that a preliminary completion report, she doesn't really even review those.
Further discussion? There a motion?
Everyone, you can read. I'm not sure. I think I'd like to hear more discussion amongst ourselves.
This is Commissioner Carney, and I see my feeling is if we gave them a timeline to get this new well drilled, I mean, that's kind of where I see some lenience there, just because I don't feel strongly. I like the malicious. I don't see that, but my deal would be to put something in writing that, hey, you have this time frame to get this 233 or 333 well drilled.
Commissioner Carney, are you suggesting that we send this matter back to staff to arrive at a highly auditable agreement with firm deadlines to get this lease cured and perfected?
Yes, that sounds.
Would you make a motion to that effect?
Commissioner Shaw.
I'd like to hear from Commissioner Shaw.
I see some merit in that, but I would like to add into that an agreement to unwind if the date is missed, so that we either have production within 6 months or we have lease terminated. I think it needs to be that black and white.
And would you, Commissioner Shaw, would you leave it to staff and the Attorney General's office to arrive at a documentation of that?
Yes, and bring it back to the board.
Is that a motion?
I'd like to have Greg in.
I just ask for a clarification. Under current policy and in previous instances where the board has determined that they will extend a lease beyond, actually the 6th year in this case, and this would be the 13th year or something. You've done it under the current leasing terms. which
Yeah, I think
current-
that was actually what
Okay.
I was gonna suggest. John, would you
Yes.
also add that, under the new lease terms, including our new royalty rate and
Correct.
bonus terms?
That's
and
correct.
a new lease document?
New lease document.
Yes.
Okay.
But at least that gives a window to perform.
I'm taking it, that's a motion.
In a very humble way, yes.
Okay. We have a motion by Shaw. Do we have a second?
I'll second. I would like a question.
Please.
Does that give you, I mean, underlying this, I mean, we've discussed performance and I mean, do you have enough with this, what's going on up here? Do you have enough?
So, yes, so we would
Good.
come up with, I guess we could clarify with the Attorney General's office if you're clarifying 6 months or if we have the ability to negotiate a time frame.
Yes, I think it's incumbent that the two groups come to a recognition of what's an appropriate amount of time so that we don't get caught in a wedge with too aggressive a
And
time.
it would be at our current lease terms and lease rates. And yes, I think we can.
And would that be worth exploring from your perspective?
It definitely would be worth exploring. I guess I am concerned about the royalty bump. I guess I'm thinking that, Renegade's perspective as we sit here today, I think I had a valid lease. As tenuous as maybe others look at it, but that's a huge bump in this particular case. It's a 1/8 lease as it currently sits and is construed, and I'm guessing you're probably talking about a bump to what, 20%? That's pretty onerous. I need to contemplate that and think about that, just both from whether to try to defend the old situation or whether to go forward with what you're proposing. I need a little bit of time to digest that, I guess.
Yeah, and I think we'd feel it appropriate to give you that time.
For context, I would offer that there's a party in the audience who's going to be in front of you briefly, who's asking for an extension on a lease, and there was one last month, I believe. And consistently, we've been increasing those rates to the current lease terms and 20%. And I think I'm probably speaking for Crystal. I think staff would have a hard time supporting a solution that doesn't include those new terms.
I would have a really hard time voting for a solution that didn't include the new lease terms. I can tell you, as a practical matter, we were very deliberate about that. Everything we're doing at this point is on 20%. And if this motion passes, Mr. Riviere, you're getting thrown a lifeline here. So I would suggest not looking a gift horse in the mouth.
So this would not be a new lease then? It would just be a modified old lease, is that?
No, it'd be our complete new lease document, is what I understood the motion to be.
That's correct.
Yeah.
I said there again, I need a little bit of time to digest. I agree, and I appreciate what the board seemingly is allowing me to do here. I need to also contemplate, I guess, though, other provisions in the lease and the implication if we're going to the entire new lease document and not just a modified royalty, there might be some other provisions in the old lease too that I have to give some thought to. I think there's in particular with wildlife mitigation. I don't know if that would impact the permitting. I think since we were under the old lease, the permitting from your guys' perspective was relatively simple. I don't know if there are now additional wildlife requirements and all things like that too are in there now.
Well, and from my perspective, that plays into coming up with a timeline that's appropriate.
Yeah, we can look into those concerns.
Okay. Commissioner Butterworth?
Yeah, I think for me, I'm comfortable with the motion. I mean, I would prefer to see us arrive at a solution here, and understand that what we're offering to you may not be palatable, but at least we're I think allowing that discussion to happen. So.
Yeah, that's why I'm just wondering to myself in my own head, and again, board welcome to sit down and see, but maybe just like a 6-month extension of the old lease with the royalty modification might be easier than a whole brand new lease. I don't know if that's.
I do not believe that is, if the first motion doesn't pass, we can always entertain a second motion to that effect. But we have a motion on the floor at this point.
Yeah.
Can
Yeah,
I ask for a clarification from the Attorney General as it pertains to the motion?
You're going to need to restate the motion.
If possible. And I'm asking this so that I understand from staff's where we would be starting the conversation. Would it be our position that the lease has terminated and we're negotiating a new lease? It's sort of to the gentleman's question, or is our position that the lease is still in effect and or is that a question you can answer at this point?
Yes, for clarification in the motion.
Yeah, the way this is Ed Hamrick, and certainly this can be clarified by the commissioners. The way I'm hearing it is that as a, I guess as a condition to not terminating the lease relationship for a short period of time to allow for drilling under the new current standard lease terms of the board, including that lease form and that royalty. So if they go into production, it's basically a new lease because you have a new lease form and a new royalty. But there's a to be negotiated very short timeline of production, and if that's met, then all lease arrangements are terminated. I'm not sure if that really clarifies your answer, but I think that's what is.
I think it did. What you said at the end is we've got a period of time to negotiate a new agreement under the current terms and conditions that the board uses, and if we're unsuccessful, then the previous lease is no longer valid, or in fact.
I may have misspoken.
Okay.
If the parties reach agreement, and they achieve production within that time frame, there's essentially a new lease. There's a new lease form, new lease royalty that governs the relationship. So that's essentially a new lease. If there's no production, then part of the agreement, as I understand it, will be that all bets are off. There's no lease relationship at all. The lease terminates, and it doesn't much matter how you characterize that. And then the third option is Renegade doesn't agree to go forward with operations under the current standard lease form and the current standard lease, and then we're sort of in a netherworld of whether the board has affirmed the termination of the existing lease.
We'll see it again next month.
Or we'll basically see it again next month to sort of complete this element. Or if the commissioners could clarify that in their motion in order such that there's a determination if there's not a resolution, but that starts to make the world complicated. But I'll work with whatever complications.
Commissioner Shaw, I get you. You certainly could do that, but I'm not sure that it sure is good faith on both sides when one side has a gun and the other doesn't. So,
yeah, no, I think the first two options are what we want to explore.
Yeah.
Commissioners, if I could ask for clarity of the record and for staff's clarity when we get to that point, a full restatement of the motion would be appreciated.
Really helpful.
It's Assistant Director Massey.
Director Ryan, do you have
No, I just want to make sure that there's clarity in the motion.
Yeah.
There should be a deadline about when we have to have resolved the discussion so it doesn't drag on forever. There should be a deadline by which the new lease has got to be signed. There should be a deadline by which drilling must occur. There must be a deadline by which there must be production. We need clear deadlines, or this is going to go on forever and
And
ever.
I think we have to have all of that come back to the board next month.
Is there any royalty negotiation aspect to it? And I mean, is there a halfway or anything like that that might be contemplated or considered?
Not at this point.
So one option would be to table the termination until next month. Basically, give us that much time to, we understand the basic parameters that the board has given us in terms of what the board expects. We can fill in the rest and bring it back to the board if the parties reach approval. And if not, we'll be back here and we'll complete the deliberation on the termination, and the board can make a decision at that point. I think that might make things a little more
Clear.
clear.
Would you be
and
comfortable with
straightforward.
Commissioner Shaw thus amending his motion?
I just,
Yes. I mean,
So move.
Would Butterworth amend his
Gotta
second?
restate it.
I am,
I can take a shot at trying to, and then you guys can modify my restatement of the motion. So I believe the motion is to table consideration of the termination of the existing lease and to direct staff to negotiate a work forward provision under the land board's current standard lease language and the land board's current standard lease or royalty rate with a hard deadline for production to be determined by mutual agreement with the parties. I think that covers everything. Have I missed anything?
I think that perfectly states your motion, Commissioner Shaw.
I'm very comfortable with
Yeah,
that.
I will second that.
there we go. We have a motion, we have a second. Is there any further discussion? Seeing none, all those in favor?
Aye.
Chair is opposed, passes 3-1. There we go.
Well done. Thank you very much, gentlemen.
I know that. So, yeah, so let's, we've got about an hour and a half to lunch coming, Bill?
Yeah.
Okay. We'll probably eat and work, but let's move on to, next item, in lieu lands.
Excuse me, are we taking a?
No, we are not taking a break. We are plugging through. So, excuse me, guys.
Audience, please.
We're moving on with the agenda, please. Chris, in lieu
Yes.
lands, number 3.
Good morning, Commissioners. Yes, good morning.
Chris, 1 second. Can I speak back?
Yeah, because you guys haven't been tormented enough. You have further torment today.
Just doing the people's work.
No rest for the wicked, brother.
All right, good to go? Good morning, Commissioners. Christopher Smith, Real Estate Section Manager. So, let's see, the purpose of the discussion today is that staff is here to recommend that the board approve up to $300,000 in investment and development funds to assist the BLM in funding reports required under the National Environmental Policy Act, or NEPA. These reports will allow the BLM to finalize an environmental assessment, and these funds are necessary to allow the BLM to reach a finding of no significant impact, or a FONSI. And you're probably asking why all these acronyms matter to the board. And the reason for this is this will allow the BLM to transfer approximately 15,000 acres to the board to settle the 142-year-old in lieu debt that staff is estimated to be worth approximately $63 million. So the properties that we are intending to study are all over the state. They are in these red the red color here and in the blue colors here. They're throughout the state. They're in 18 different county, and there's 93 different parcels. So by way of some background, the in lieu debt dates back to 1876, which is the year that Colorado became a state. There are approximately 10,000 acres of real and phantom acres that are owed to the board. The reason I use the term phantom acres is in some cases, the land that was owed to the state was cut off by a state line. So it may exist, but it may not exist in Colorado. They are also lands that were owed to us that were already spoken for. So they may have been in Native American reservations. They may have been issued as mining claims or land grants. And over the last 6 years, staff has worked together with the BLM to identify lands and to use a methodology to value those lands. So we have come together, we've agreed on the methodology, and we've applied it to the roughly 10,000 acres that were owed. That has established a dollar value debt of approximately $63 million. And then we took the next step by applying that same methodology to approximately 93 different parcels statewide, totaling 30,000 acres, that the BLM would transfer some of those to us to settle the debt. So we are studying 30,000 acres. We believe this is approximately twice of what it will be needed to settle the debt. And while the debt is owed in land, we've converted that to a dollar value, and then we will settle it in land, if that makes sense. So in 2012, this board took action to initiate this process. We presented the 93 parcels to the board at that time, and they approved acceptance of us moving forward. In 2013, in working with the BLM, both parties thought that we were going to be able to move this forward without doing the studies under the National Environmental Policy Act. The reason we believe this is because this debt predates this act. However, the BLM sought an opinion from their solicitor's office, and that opinion was that we do have to go through NEPA and all the studies required under NEPA. Those studies include cultural studies, they include hazardous material studies, and they include threatened and endangered species studies, amongst others. In 2015, the BLM determined that all of the 93 parcels were suitable for exchange, and they really began in earnest doing all the studies that are required under NEPA. At this point in time, those studies are complete. However, we need to hire a contractor to write an environmental assessment or an EA to really synthesize those studies into one document. So that is the next step. Thus far, the BLM has spent approximately $900,000 to this end. Those are real dollars. They've also spent hundreds of hours of their staff time on this. And at this point, there's no additional funding appropriated by the federal government for this. So the BLM has asked us if we could come to the table with up to $300,000 to fund this final environmental assessment. Staff did we have had ongoing discussions about this. We did ask if this could be reimbursed either in cash or in land. Again, the BLM sought an opinion from their solicitor's office, which said that is not possible. So this would be an expenditure to the board. It would not be a loan or a grant of any sort, or it would be an expenditure.
It is a grant. It's okay. Yeah, we're granting the federal government.
So staff is recommending that the board approve up to $300,000 in investment in development funds. We have, in looking at this, we've tried to identify the risk in the board doing this. And the risk that we've identified is that the board expends funds to pay for this study, but the results of the study are unknown at this point in time. And the study may conclude that there are significant negative impacts, that if that happens, those significant impacts must be addressed in order for the exchange to go forward. But in anticipation of this, approximately 6 years ago, State Land Board staff and BLM staff really overbuilt the amount of land that we're studying. So again, we're looking at 30,000 acres to study. We believe it'll take 15,000 to settle the debt. And so the way of mitigating properties that would be negatively impacted by this is to simply drop them off the list. So the overall exchange would not be negatively impacted. So should the board approve this today, the next steps would be to for the BLM to seek bids and contract for the completion of the environmental assessment. We would then come back to the board with a final list of properties for approval. The BLM would issue a finding of no significant impact, or a FONSI. Following the issuance of that, there's a 30-day appeal period to the Interior Board of Land Appeals. And if there's no appeal, then the BLM can issue what's called a clear list, which is the instrument of transfer, similar to a deed or a patent, to the board, and the debt is settled. So with that, staff recommends the board to.
So easy.
Staff recommends the board approve up to $300,000 of investment and development funds to assist the BLM in funding reports required under NEPA to settle the in lieu lands debt owed to the board. I'm happy to answer any questions. And also John Beck, the acting deputy state director, is here and is available to answer any questions as well. Yes.
Commissioner Shaw, has there been any cash expenditure on behalf of our group to date?
Only staff time, no funding.
Okay, thank you.
And this expenditure, Nick, I'm kind of looking at you, falls within the parameters of the I&D expenditure. There's no question about that. Okay. All right. Chris, my question to you, I may have previewed this, is I'd love to get a more detailed map at some point.
Sure, Commissioner. We have 93 separate maps also. I can send you a statewide map, or I can sit down with you with lots of, but absolutely.
Thank you. And given this is probably an off the wall question, but given the current political environment about the transfer of federal land to state, do we anticipate any political blowback on this? I mean, this is owed to us. This is not like what's going on in Utah, and I could straight face a room full of people. But have we got a little spidey sense going on about this at all? Or
I think I'd like to invite John Beck to come up. The BLM has had 2 public hearings on this since we've identified the 93 parcels. They had to classify these parcels, which means they had to publish them in the Federal Register. They had to publish a notice of proposed classification and then a second classification notice, both of which came with a public comment period.
Correct.
So, and you received 3 comments?
Yes, we didn't receive too many comments. So we're not too concerned about it being controversial.
And actually, can you introduce yourself?
I'm sorry, yes. John Beck. I'm the acting deputy state director for resources and fire for BLM Colorado. So yeah, to get back to that, no, we're not expecting a lot of controversy with this. Some of the comments we got were from some of the local counties concerned about federal land leaving federal ownership, and therefore their payment in lieu of taxes would go down every year, but it's very insignificant. We don't think that that's a serious concern.
Yeah, I was going to say it's not big.
It's not big at all, and yeah, not at all. Some expression about some impacts to wildlife. The Gunnison sage grouse was brought up. However, those particular parcels where they did raise that concern, we think the state will actually make those part of a state wildlife area, so therefore we don't think there would be an impact. If there were, we could always drop those parcels as Chris notified. We did not hold hearings yet. We did public notices by publishing in the Federal Register and local newspapers about this, and that's how we solicited public comment. We would intend, if we go forward with the NEPA analysis, that we probably would hold a public opportunity for a public meeting.
Is there any risk of this number increasing, or are we come back 300,000?
Oh, the dollar number.
Right. Sorry.
John and I were just talking about this morning. It is possible the number will increase, but the BLM, or John has indicated that the BLM may be able to fund that in the future if that is needed.
Right, that's our estimate. We think it's a pretty good estimate. Normally a NEPA analysis of this magnitude with this many parcels and spread out throughout the state would be much more expensive. But because the preliminary work we did ahead of time with issuing private contracts to inventory for cultural resources on all the properties, some of those are complete, others are ongoing, will be finished by the season. We also entered into an interagency agreement with the USGS that we piggybacked on another agreement that allowed us to pay them to do a biological assessment. So with all that data, we will provide that to the contractor to compile it and do the analysis, so it saves a great deal of time and money.
The BLM is committed to get this deal done. Are we comfortable?
Well, after 146 years.
Yeah, we've been waiting a long time, so.
Yes, we are. It was kind of, I think it all started from a meeting of the Western Land Commissioners talking with our Washington office. Some states very unhappy that the debt hadn't been settled. Colorado, not so much. We've always had a good working relationship with the State Land Board. Was there a lot of BLM land that the state was really interested in? Probably not, but there was discussion that these debts need to be satisfied. So Washington pretty much gave us orders to work with the state to do that. That's where we are now.
If I can ask a question, John. With all due respect, since we've started these discussions, the local office says, let's do it. And then someone in Washington steps in and says, we're changing the rules. You can't do it this way. And then we say, okay, well, we'll pay for that and you'll reimburse us. And then Washington steps in and says, you can't do that either. How do we get an assurance that you're as committed to this as you can possibly state, and that someone in Washington or a solicitor or somebody else isn't going to weigh in and derail all this after we spent the money? And then the studies that you've done expire by time and we've got to start all over again. And that's been my big fear in this. I want a letter that commits the BLM in the strongest way possible before we go spend the money of the school children. And some bureaucrat somewhere far, far away says, nope, we're not doing it. So how do we help us feel good about that?
And you can certainly let the bureaucrat know that our PIO will blame them for taking money from school children in Colorado when they queer a deal. So,
right. Well, I mean, the statute's the first issue, of course, that we've owed this land since actually the Enabling Act was 1875 that laid out the parameters that had to be met for Colorado to become a state in 1876. So we owe that under that statute. We know that the fact that we did an initial classification that was done through a screening of what properties we thought were available through our land use planning efforts. We then looked at those properties a little more closely with all of our field offices to screen them for known resource concerns. So properties were dropped out from our original analysis. Then the final classification that was done, I mean, it demonstrates our commitment to go forward. And Chris does have a letter that was just signed yesterday from our state director that does state we are committed to finishing this project.
That is new news to me. Thank you.
It just was signed yesterday.
Yes, and John hand-delivered it today, and I quote from the letter, "The BLM is committed to completing this project and settling the century-old debt."
Thank you. Any other?
I withdraw the earlier comment.
Yeah.
I just knew that question was coming.
Any other questions? Any public comment on this? Seeing none.
Go ahead. No, take it away.
This is Commissioner Carney. I move we approve up to $300,000 investment and development funds to assist the Bureau of Land Management in funding reports required under the National Environmental Policy Act to settle the in lieu lands debt owed to the board.
That is a motion by Carney. Is there a second? Second by Butterworth. Any further discussion? Seeing none. All those in favor?
Aye.
Chair is also in favor. Passes unanimously. Thank you.
Thank you.
And I have been informed that lunch is here. So what I'm going to suggest, given our timetable, is that we take a very quick break, go get some food, come on back in and go back to work, and staff and the public can watch us talk with their mouths full.
Thank you.
Thank you.
Thank you.
Give you a little break.
Yeah, thank you. I appreciate it.
I'm ready. You're right. It was a test of will. brief break. It is the continuation of the Thursday, March 15th, 2018 meeting of the Colorado State Board of Land Commissioners. We are well into the final action portion of the agenda on to item B, oil and gas lease 106450, 106451, 106455, and 106630, 7th year extensions, Long Peaks Resources LLC. Katie has kindly consented to talk while we eat, so thank you.
You're welcome. Good morning. For a few more minutes, Commissioners. Katie Stitt, Oil and Gas Specialist for the State Land Board, and I will be discussing a 7th year extension request from Longs Peak Resources regarding 4 of their leases. This is a map of the state of Colorado. We are going to be focusing on the north central part of this map, which is highlighted in pink. And the 4 leases in particular are located right in the northernmost center part of that district, located with the star. This map I'm going to tell a little bit of a story about. You all love my map stories now, sure. We are talking about 4 leases. These are the 4 leases we are discussing today. These are fairly closely located to each other, and they're all located right along Highway 85. This is going up into Wyoming on the north, or on the upper part of the map. If you continue back down on 85, you'll end up in Eaton, and then Greeley to kind of locate yourself. So these are all pretty closely clustered together. Longs Peak is the lessee of record on all of these leases, but Longs Peak has quite a few leases in this area. They have all of these. So they've really kind of aggregated quite a cluster of acreage in this area as part of their overall drilling plan. Some background on why you get to hear from me. Back in December, we modified our oil and gas development policy to require the board to consider any extensions beyond the 6th year of an oil and gas lease. This is the 7th year of these leases, so that is why we are here in front of you today. Staff is recommending that we approve the 7th year extension with a fair market bonus payment and increasing the royalty rate on these 4 leases to the current royalty rate of 20%. So here's another fun map. This map is from the Oil and Gas Conservation Commission, which is why it looks different from our maps that we produce in-house. Highway 85 has turned green in this map, but this is still Highway 85. And I've outlined the 4 leases that we're talking about in this pink outline, which hopefully you can see here. To talk a little bit about what this map shows, basically all these long lines going across the map, these are all horizontal well bores that are either pending approval from the commission, or they've gotten their permits approved, but very few of these have actually been drilled as of yet. Longs Peak has actually applied for spacing and has gone through the process on this entire block of land. So you can see this is quite a robust development that they have planned here. They have received these leases, the 4 leases in particular, and quite a few others within the last year and a half. And they've been moving their way through the process with the commission. They have actually successfully drilled and started production on several leases in this area. Most of these permits were approved within the last 2 months. That's how quickly they have moved forward with this process. So there is, unfortunately, some delay with the commission. I can't speak to their workload. I'm sure it's very robust. And I'm sure they're trying to do the best to expedite. But when these permits have been approved, this lessee in particular has taken the initiative to get things going as quickly as they can. So this whole area essentially is under the control of Longs Peak Resources. Questions so far on this? Okay. So as I mentioned, lessee has been actively pursuing development since acquiring the leases last year. They've been very proactive and communicative with us about what they're doing on these leases, and their current development plan with where their status is in the commission process should result in a development on these areas much sooner than if we were to go about issuing a new lease with potentially a new lessee in the mix. So as a result, staff is recommending the approval of the 7th-year extension at the following terms. A little bit about the market rate bonus that we determined. Staff spent a significant amount of time looking at what the land in that area has been selling for. Longs Peak has acquired some of these parcels in auction within the last 2 years that's in that immediate vicinity. We've looked at what they've paid per acre. We've looked at what other folks have paid per acre. And we spent quite a bit of time doing an analysis on that to make sure that any recommendation we were to give at this point would fairly represent what we think would be received during an auction process. So that's where we came up with that bonus per acre. And then their rentals would be the equivalent rate that they're paying now, which is consistent with the modern lease. Any questions? So I do have representatives from Longs Peak. They have a little bit of a presentation to give you, and you can answer, and they can answer any questions you may have about their development. And
great, thank you, Katie. Before the folks from Longs Peak come up, any questions for Katie? No. As usual, thorough and well done. Thank you. So come on, folks from Longs Peak, come on up and introduce yourselves. And
okay.
I'm in, don't worry.
All right. Good afternoon now, officially, commissioners. I think this sounds like I'm on. My name is Jill Fulcher. I'm an attorney at Beatty & Wozniak, and we represent Longs Peak Resources. And with me here today is Kent Snyder. Mr. Snyder is Vice President of Land for Vertex Energy Partners, which is the parent company and agent to Longs Peak Resources. Ms. Stitt did an excellent job giving an overview of the leases that we are asking for extensions for today and their location and in the current status of the drilling units in the area. So I'm going to do my best to keep my remarks brief, recognizing that I am an attorney and it's my nature to not keep my comments brief. And then Mr. Snyder is going to go into a little bit more detail as to Longs Peak's drilling activities in the area thus far, its larger plans for development, the current wells that are producing, which are also all state leases. So we are providing revenue to the state right now based on the drilling we've done, and then talk a little bit about the need for the extensions. So with that, I'm going to move into our first slide, which I'm going to talk about very briefly because Ms. Stitt already indicated the leases that we are asking for extensions for today. This slide provides the lease identification numbers for those leases, the legal description for the leases, and the original expiration date, and then the date we're requesting. So as you can see, we're asking for 1-year extensions on these 4 leases, which would take us into February of 2019. I'm going to move right along to our next slide. Our next slide talks in a little bit more detail as to the status of the drilling units that have been established by the COGCC with respect to these 4 state leases that we're asking for extensions for today. As Ms. Stitt indicated, Longs Peak has undergone significant development plans over this past year in this area and then in northern Weld County as a whole to develop thousands of acres as part of its macro full field regional development plan. And as such, we've actually already received approved drilling units from the COGCC for 3 of the 4 of these state leases, which, as I'm sure you all know, is a necessary precursor to drilling. Before an operator can get a permit to drill a horizontal well from the COGCC, we must have an approved drilling unit as a result of the various tracts and divided mineral ownership. So we've done that. We have 3 of those units approved. We have 1 final unit that is yet to be approved, but we have applied for a spacing order for that state lease. That's the final lease that's listed. We had expected to receive approval from the COGCC for that unit this coming Monday, but we just learned yesterday evening that that application is being continued by the COGCC staff just as a result of their workload. They are processing a record number of applications right now, and so we understand that they needed to continue that solely for that purpose. It's not been contested, and there's no issue with our testimony. It's simply just a result of some understandable backlog. So we expect that that unit will be approved April 30th from the state. Within each of these units, or excuse me, state leases as well, we've already filed applications for permits to drill. And in 2 of the 4 leases, those APDs have recently been approved. So again, another precursor to drilling has been achieved by Longs Peak. And then the other 2 state leases, within those two state leases, the APDs have been submitted. They're just pending approval, and we expect the approval to be given by the staff, by COGCC staff in the next few months. So Longs Peak has satisfied these 2 precursors to drilling, and in that way we really have the momentum to drill this acreage. And the final point I want to make before I hand it over to Mr. Snyder is just talking a little bit about Longs Peak's development plans over this past year, and which speaks a little bit to why we're asking for the request today. In 2017, Longs Peak focused its time and its resources on developing a strategic plan for development for thousands of acres in northern Weld County. And as part of that, we filed numerous drilling and spacing unit applications with the commission, and also filed 293 applications for permits to drill just in 2017 alone, 99 of which have been approved, and we expect the balance of those APDs to be approved in the coming months. But ultimately, we felt that by focusing on this macro development, we could more efficiently and economically develop these resources versus going in piecemeal. And we also felt that this would better secure our rights to operate based on state regulations. So that was the focus in 2017. The focus in 2018 will be implementing that plan and drilling. So we wanted to call that out, and that's the primary reason we're here today, is asking for this extension so that we can have the time necessary to implement that drilling plan on these remaining 4 leases and generate more revenue to the state fund. Before I do kick it over to Mr. Snyder, I will say that we have drilled 3 wells this past year, which are all now on production, and each of those 3 wells included state leases that are not subject to the request today, but are generating revenues to the state. So with that, I'll hand it over to Mr. Snyder, and we're happy to answer questions now or following Mr. Snyder's remarks.
Thanks, Jill. Just quickly, if you look at the map that's up there, we bought this acreage. We bought 20,000 acres 2 years ago in January of 2016. We now have almost 80,000 net acres up here. So we've got a huge commitment. We spend a lot of time and effort putting all this together and getting the spacing units, as Jill has said. And it's you never have enough time in the oil business. The clock's always ticking and you're scrambling to do things. We came in, most of those leases had 2 or fewer years left on them. So we have renewed, we've extended, and we bought new leases. So we feel like we're really making a great effort to try to develop this area in an efficient manner. These 4 leases are key to our exploration program. If we can get these extended, and I think we're probably the most obvious ones with all our spacing units to do this, we will have this, hopefully, the plan is for October and November to be drilling on these leases. And that way, with flow back and things, I'd say early January, February, you should see be reaping the benefit of some of the royalties. Now, Jill alluded to the 3 wells we drilled. The last one on the west side in section 31 is still flowing back. It hasn't been put on steadily, but you'll start receiving royalties on that shortly. The first 2, to date, we drilled the Motu well on the far east in late 2016, followed it up with the Pismo well in section 35. And those 2 wells have generated, through February of this year, have generated $324,000 to the state of Colorado. And with the new one coming on, and with the ability to come in and drill these, if we're fortunate enough for you to extend these, there's going to be some good royalties, and it's going to be done quickly. So we just ask that you look at our request. We appreciate the consideration that you give it, and hope that we can add to the coffers of the state land board. I see there's $100 million a year we won't make a big dent in that, but we'll add to it.
Anything you can contribute to,
Nickels, up dollars.
yeah, the school children will
If we can
appreciate.
do 1
so.
or 2%, it'll be good.
Yep.
Be good for everybody. And our interests are aligned. I think it's something that can be done very well. And the new lease, if you extend these, we'll have 20% royalty on them. The old leases had the 6th. We have no problem with that. And Kitty did a great job of evaluating the bonus, by the way. I think I'm going to try to get her on the next auction and see if she'll help me.
All right. Any questions? No, none. Thank you. Real quickly, any public input on this item? Thank you, folks.
Commissioner Butterworth, I'd move approval of the 7th-year extensions of Colorado State oil and gas leases 106450, 106451, 106445, and 106630 at a 20% royalty rate and a bonus of $156.25 per acre.
Motion by Butterworth.
Second.
Second by Shaw. Any further discussion? Seeing none, all those in favor?
Aye.
Chair is also in favor, passes unanimously. Thank you, guys.
Thank you very much, Commissioner.
Thank you. I would like
Yep.
to say the staff you have here is second to none. I deal with a lot of state and federal offices, and these guys are great. They're professionals, they're responsive, and they're working hard for the state of Colorado. So
Thank you.
Thank you. Fortunate. We appreciate it. Thanks.
Just met the minerals team, Matt.
Next up, Crow Hill IND request, Park County, Julie Majors. And
Courtney.
How are you?
Good
I was
afternoon.
going to say, it doesn't. You don't look like just an
I was
envelope.
gonna say,
Courtney, come on.
apologize for the agenda. It's Courtney who's doing the heavy lift on this one.
Yep.
Good afternoon, Commissioners. I'm Julie Majors with the Real Estate Section. I'm here with Courtney Hurst.
Good afternoon, Commissioners. My name is Courtney Hurst, and I'm the Resource Specialist covering the South Central and Southeast districts of the state.
And the item in your packet this afternoon is the Crow Hill Investment and Development Fund request. Staff is here to request up to $90,000 in investment and development funding from the Maintenance and Reserve Account to demolish 7 structures on 233 state trust land on a 233 acre state trust land parcel. We did complete an asset plan in 2017 on this parcel. That asset plan has informed this request, as well as the board's strategic plan mission for stewardship. So I'm going to talk a little bit about the summary of the asset plan that we did, and then Courtney is going to take you through the details of the request. So the property is in Park County. It's in the northwest corner. This is a great map that shows you the property's relationship to Staunton State Park, Pike National Forest, Pine Junction on 285. That's actually County Road 126. And then to Bailey, Colorado. The property is about 10 miles south of the Pine Junction intersection. This is a great aerial. It shows you how really forested the property is. And it also shows you that we have 2 points of access for the property off of Highway 285. The first access, there's a lighted intersection, and then you would come down an access road called Arcadia. And if you've ever eaten at Hog Heaven,
I was
which
sorely
is a farm,
tempted last night, I gotta tell you.
You would have been right next to the property. The other way to get access is on the south side, and you would exit either southbound 285 or you can come up northbound 285, and you would land at this cul-de-sac here where, in fact, our current lessees operate There's a ball field here with Park County and some other.
That's on our property?
Yes.
Okay.
Yes. So I do have possibly a little treat for you today, brought to you by our recreation manager, Abe Medina. This was one of the properties that he used as a test parcel for the state drone. So this is actually going back to the map that we had. This is really looking northwest and northeast. I was trying to get, here we go. So this gives you a great feeling of the property looking north. Lone Rock Ranch is right here. And as we move towards the north of the property, you can see Acadia Street here. You can see 285 northbound and southbound. And as we get here, you can see the actual, I'm going to stop it for a minute. You can see the actual entrance into the structures that we're going to be talking about a little bit more. The drone actually flies northwest, and if you were actually going to take one of the roads up, you'd end up at a clearing where you would have great 360-degree vistas of Mount Evans, Lone Rock Ranch, and then Westerly. So it is a beautiful piece of property. It's one that the board should be really proud of. So in 2017, as I mentioned, we completed an asset plan, and even though this property is just over 200 acres, it has a lot of challenges and it's got a lot of opportunities. So we felt like it was one that we would prioritize. For the asset plan, we looked at the historic significance. We do have a historic review by Park County. We looked at the leasing opportunities for agricultural. And we looked at the comparison of the 2010 appraisal versus the value in 2017. And then we also looked at what we might do with the property, and if we were to dispose of it, what would that look like? So I know the asset plan was in your packet. I'm not going to go through the details of each one of these points. Happy to discuss any of those if you would like. But I think the conclusion of the asset plan indicated to us that there was really no reason to run out and put a disposition sign on the property. We can revisit that in 5 years. The property's not going anywhere. It's in a great location. But that in order to be good stewards of this property, we really need to look at securing it and removing the trespass and liability issues that exist with the existing structures. So at this time, I'm going to hand this over to Courtney, who's going to talk to you a little bit more about the specifics of the request.
Courtney, you didn't do the painting on the building, did you?
I wish I had. It's pretty good.
It is
cool.
It's
It is
actually
pretty
good. Yeah.
Okay, thank you, Julie. With this slide here, I just wanted to provide a bird's eye view of the proximity of Highway 285 and Arcadia Road to the buildings on property. The red square, just for reference, is about 2 acres, give or take. And with respect to access to the property, it is along this 2-track road, as Julie indicated, and this access is at this time only restricted by a single thick cable across the gate opening, and this cable is in no way locked. So a person could simply step over the cable, or if they had a vehicle, could lower the cable and drive on into the property. These photographs here are to give you a sense of the site as it is today, as well as just an overview of the buildings back in 2010. Roughly, the buildings go from northeast to southwest as you go from photo left to photo right on the top photo. The lower photographs I took during a visit in July of 2017. And as you can see, there is the great moose head on the side of the barn.
Who did it? Any idea? Somebody just
Unknown, yeah. It was a surprise to us, I think, when that was.
We didn't commission it.
No.
That's crazy. Some guy needed a blanket.
Sure. I've been asked to reintroduce myself. So my name is Courtney Hurst, and I'm the resource specialist covering the South Central and Southeast districts of the state. So these lower photographs, one of the things I'd like to call your attention to is this second photograph from the left. This little gray circle is what I took to be a bullet hole when I was in the field. So someone's been shooting at the buildings. And then the right two photographs give you a sense of the condition of the house. As you can see, both the front door and the sliding glass door, which is here, are standing open. There's trash both on the inside and outside of the house. And most of the windows are either broken, missing, or boarded up. I did go inside of the house with some contractors that I'll mention a little bit later, and it is full of trash. There's at least one place where there's a hole in the floor that you can see into the lower level of the house structure itself. So the house presents a real safety hazard and a liability for us. So with that in mind, we took a look at removing these structures and realized that it was quite likely that they contained asbestos. So an asbestos assessment was done of the site, and three of the 7 structures did return positive values for asbestos. The house structure has the most, with asbestos being contained in the walls, the ceiling, the flooring, pretty much throughout the house itself. While the other 2 sheds, it was simply found in the roofing materials. So with that in mind, we solicited 3 bids from contractors who could both remove the asbestos and then go ahead and demolish the structures on site. Of those 3 bids, the lowest for the combined effort was $82,000. So it is our recommendation that staff believes that it is in the best interest of the school trust to approve $90,000 of investment and development funds to demolish the structures at Crow Hill property in Park County.
Courtney, is there plumbing on site? The house have plumbing?
Well, I don't know. I mean, if it's there, it's probably not functional. I don't know if there's anyone here.
Probably a well.
Was there indoor plumbing at some point? Probably?
Yes.
Yes, there was indoor
Yeah.
plumbing, but it's got to be on septic and well. There's no municipal services over there.
Great, thank you. I'm Greg Moffett.
I'm Greg Okish.
So
I'm speaking of dulcet pear-shaped tones that should be obvious to everyone.
So I guess at this time, we'll open it up for any question or comments that folks might have.
Just, obviously, I stopped by yesterday. I agree with the asset plan. This is God's little acre. It's a beautiful piece of property. I don't know what Park County has got in mind. It seems to me like this is an excerpt. I drove towards Denver at evening rush hour. I was taken aback at the number of cars driving towards here which is really, it's a good hour almost from downtown Denver. But I guess if you want to live in the country, this is the country.
This is Julie Majors, and to have quick access to urban areas, yes, that's why we do believe that this site offers a lot of opportunity. I like to use the term rural infill because it's at that place where it's a great rural site, and there's so many things around it. The Berlin Ranch community that's to the south, and I mean it really is a piece that if it had infrastructure and utilities would be a very attractive development site.
Interestingly, part of the reason I wanted to drive it was I wanted to see how close it was to Breckenridge because they've got a huge workforce housing shortage and it's not close enough.
Right.
On the other hand, it's probably no further away from Breckenridge than Rifle is from Aspen. And it makes it once again, an interesting location for people who don't have to commute into the city every day and want to go up to the mountains on the weekend. It's just well located. So yes, sitting on it makes a lot of sense.
I don't think we're going to be losing any value on this property.
Yeah, but we're not generating any income in the interim.
No.
Okay.
No.
And the Only question I have about the asbestos is friable or not? I mean, sometimes there's an argument for leaving it be. Assuming that at 90 grand, I'm having a hard time coming up with that argument, but is what we're taking out. Are we, if somebody's in there because it's an attractive nuisance, are they going to be breathing the asbestos if we don't?
I think,
Not
I'm
sure.
sorry, I read some of the early proposals and it's been a while, but I think we have some of both, some friable and some that's, I don't know that that's a particular health risk to somebody vandalizing the buildings, but it plays into our thoughts about getting them taken down entirely.
Any other questions or comments? Any public comment on this item? Seeing none. Chair would entertain a motion.
Move approval of investing $90,000 of investment and development funds to demolish the structures at the Crow Hill property in Park County.
Motion by Butterworth.
Second.
Mike Carney. Any further discussion? Seeing none, all those in favor?
Aye.
Chair is also in favor, passes unanimously. Thanks, guys.
Thank you.
You had mentioned at one point, yeah, sorry, it's Bill, but I'm not on the item, so maybe it doesn't matter. That maybe there was a way to score some points with Park County by letting their fire department utilize this at the end. That's a place where we've had some difficulty up there. If we go that route, can we work with Kristen to make sure we get some really good PR out of that? It's been a challenging community for us.
Okay.
The county bill?
Yeah.
Okay.
Well, at least the neighbors.
Okay. The Berlin folks, or?
It was I'm blanking on the name of the parcel where we wanted to do a recreation lease. Neighbors opposed.
All right. Next on the agenda is the Bronco Pipeline right-of-way, Lowry, Arapahoe County. David.
Good afternoon, Commissioners. David Rodenberg, aka Charlie. Real estate section, right-of-way program manager. This board agenda item is a staff recommendation for board approval for a right-of-way application from Bronco Pipeline to install a 12-inch natural gas pipeline, a 6-inch natural gas pipeline, a 8-inch crude oil pipeline, 4-inch water pipeline, and 3 bundled fiber optic communication cables, and 3 above ground surface appurtenances that are along the route. This is all within the 50-foot width that they're requesting, approximately 11,211 feet, which equates to approximately 12.87 acres. This item is before the board because the parcel is in stewardship trust. Parcel is located on our Lowry Range parcel, which most of you all are familiar with. It's located here in Arapahoe County. This is an overview of the entire Lowry Range. The right-of-way starts here and comes down along an existing road here and ends at another well pad here. These other lines you see are other oil and gas pipelines. I don't show all of the right-of-way encumbrances on this map because it gets a little messy. Just want to make sure it was clear where this right-of-way was in relation to the other pipelines. This is a closer view of the pipeline. Again, it starts here, connects to this well pad and an existing Bronco pipeline, cuts across here and then down again an existing road to this other well pad. Also wanted to mention that this hook here that is in the stewardship trust was approved, presented and approved by the board a couple years ago at a board meeting per staff's recommendation. So this map shows the different tiers related to the stewardship trust program that we have. And a little harder to see, but again, it's the exact same map. The route comes across over here and down and crosses 2 different tiers, tier 4 and tier 2. And Mindy Gottsagen, our stewardship trust manager, is here to talk with you about what the tiers mean, just to remind everybody.
Sure. Mindy Gottsagen,
the Conservation Services Manager for the State Land Board. The tier mapping system was developed by by staff and then approved by the board in 2012 in anticipation of the Lowry Ranch being offered for oil and gas leasing. Only the part of the property south of South Quincy Road or East Quincy Road is actually in the stewardship trust, although the tier mapping applies to the entire property. So it's a 4-tier system, kind of the tiers representing different zones on the property. Tier 1, which is shown in light green, is actually no surface occupancy, and that represents either the highest natural values or lands that were already committed for other purposes. Tier 2 is the one with the next higher natural values, and it has kind of a modified surface occupancy. And then Tier 3 has a kind of the lowest natural values, with then Tier 4 actually being those areas that were previously disturbed. This whole system was developed to incentivize development in the previously disturbed areas and usher it away from the areas with the higher natural values. So you can see that the proposed pipeline, which is harder to see on this map, but actually goes through as much of Tier 4 as possible, which is the pink areas. So it's being located exactly the way we wanted it to, away from Tier 1 and 2, and concentrating as much as possible within Tier 4.
Thank you, Mindy.
Sure.
So Bronco Pipeline is a business entity created by ConocoPhillips for purposes of building the infrastructure to support the oil and gas development, of which ConocoPhillips holds the oil and gas lease with the State Land Board. The pipeline system provides a gathering system required to service Conoco's operations on the Lowry Range, and additionally to potentially serving other ConocoPhillips mineral leases outside of the Lowry Range. So staff used the standard per rod pricing method on this particular right-of-way application. The base rent or consideration payment, I should say, is based off of a 50-foot wide right-of-way and is $85 per rod. The additional uses, because this is part of a system and not individual separate uses, we are charging $25 a rod for that, or recommending charging $25 a rod for that, which equates to $16,987. This next line item is for the temporary workspace that they are requesting, which equates to $8,493, totaling $83,235. Our North Central District Resource Specialist inspected the route and reviewed the proposed right-of-way and believes that it follows the most direct route and minimizes impacts to the natural values on the property. As mentioned earlier, this is in stewardship trust, and it required a specific review process, which Mindy, our stewardship trust manager, is going to speak about.
Sure. So because this is in the stewardship trust, there's certain requirements that are made for any proposed new use. So we make a notification of new use, and that involves notifications to the original nominators, of which there were 5. Current lessees for these sections in total 9. We always also notify local government, which in this case is both Arapahoe County and the city of Aurora, because they're within 3 miles. And then any appropriate state and federal agencies, which in this case was Colorado Parks and Wildlife, the U.S. Army Corps, because they're involved with the cleanup of UXO, and also the Colorado Department of Health and Public Health and Environment, I think, because they're also involved with the cleanup. We received 5 comments. Only 2 of substance, 3 basically say they had no comment and it had no problems with it. We got a comment from Intermountain REA, which is the utility, and they wanted to make sure that because the pipeline will pass underneath the power line, they wanted to make sure that we observed certain height restrictions and grading requirements, I think. And then we received comments from Colorado Parks and Wildlife. And ConocoPhillips, as you may know, this is, I think David mentioned, but this company is a subsidiary of ConocoPhillips, and had this actually come under and been proposed by ConocoPhillips themselves, we wouldn't actually be reviewing this, but because it's a subsidiary, it's considered a new use and a separate lessee. But ConocoPhillips have, as part of their agreement with us, they do all this kind of environmental monitoring and management. They've were able to respond to all of CPW's concerns based on their recommendations. So that's all that I have.
All right. Questions? Seeing none. Public input on this item. Also seeing none, I see a proposed board order on page 219 of 259. If somebody were to make a motion.
Commissioner Butterworth, I move approval of right-of-way application number 4048 per the terms outlined in our board order.
Second. And we got a motion by Butterworth, second by Shaw. Further discussion? Seeing none, all those in favor?
Aye.
Chair's also in favor, passes unanimously. We're going to go out of order for reasons.
I want to make sure that we get the
cropland.
policy
Yeah,
done
absolutely.
before the hearing.
Yeah, so let's go to cropland leasing policy revisions, tab 11. We got Matt to drive all the way, and we'd hate to have that go for nothing.
Good afternoon, Matt Pollard, North Central District Manager. I'm here today to recommend revisions to policy 300-006. These recommendations have been formulated as a result of staff findings and information gathered subsequent to the board's most recent review of the policy in July of 2017. This is an action item. I'll give you some background and tell you how we formulated the recommendation, and then have time for questions. So cropland policy 300-006 states that it shall be reviewed by the board at least every 3 years. As such, I will review the developments that have come about from the last 2 reviews of the cropland leasing policy. So in 2014, the board reviewed the policy and continued the use of a long-held formula. That formula is simply a 25% crop share converted into a cash lease. So to review that, it's simply the yield times the price times the landlord's 25% share times an additional 50%, which reflects the prevailing practice in Eastern Colorado of fallowing every other year. So in practice, this should very closely mimic a true 1/4 crop share. In 2014, going into 2014, the county average yields had traditionally been used in the formula, going back at least 30 years. In 2014, the board revised the language in the policy to reflect the use of actual yields when available via crop insurance yield reports. It's important to note, a recent study showed that 86% of U.S. acres that are eligible for crop insurance are currently insured. So that shows you how common this has become now, that growers insure their crops. As such, there's yield data on those acres that carry this insurance. So in 2014, the board requested that lessees provide this yield data to the board. It's important to note at this time, this change was not made in a vacuum. It was a result of a 2012 outreach effort in which staff had convened a roundtable or working group comprised of farm organizations and producers, and made that recommendation in 2012. The board implemented it in 2014. So kind of the rest of the story then, this next slide is less than 1/3 of the lessees submitted the yield data per the request in 2014. Matter of fact, significantly less than 1/3, maybe more like 10%.
Matt, can I ask, and which ones were they?
Typically it was the ones who their rate was lowered because their production records were lower than the average.
Figured it out.
There were a couple, I will give credit. I had a few lessees that voluntarily provided their yield reports and it doubled their rent. And I've really respected the fact that they did that. So we fast forward to 2017. It was time for a review again of the policy. We came before the board with essentially one recommendation, and that was to require lessees to submit the yield data using 10-year average crop insurance report yield data. And I would remind the commissioners that the data collected was for the state lease land only. It does not request any data relevant to the lessee's other lands. And so I don't expect you can see this on the report. I simply put it in here as a placeholder. It's in your packet. It's an example of what a crop insurance yield report looks like. It's simply the one up there. It lists 10 years yield data, and the bottom line gives you the average, simple average, 36 bushels per acre. The second form in your packet is simply a different insurance provider, slightly different format, gives the same data. That one, the conclusion is 45.8 bushels per acre is the 10-year average. So subsequent to the 2017, that was July of 2017, this board made that revision. Staff notified the lessees of the policy change. We asked them 30 days, within 30 days to please submit those reports. Some districts then actually sent reminder letters. And eventually we were successful in gathering 70% of the leases. Now, bearing in mind, a small portion of those were affidavits stating that they had no crop insurance. That was one of the provisions that the board made, is that if you don't carry crop insurance, we just need an affidavit stating that you don't have those figures, and we would revert to county averages. So we collected 70% of the yield data from our lessees. And now about our findings. I guess the bottom line is we were maybe surprised by just how high some of the yields were out there. The actual yields were above county average. And so in making our recommendation the recommendation today is going to be to revert to the practice of using county averages for the time being. And this is why. Our findings showed that some rents will increase over 80%. So for an example, Weld County, the average data supplied by USDA says that the county average is 24 bushels per acre. I've received several yield reports that show they're averaging in the high 40s, even to 50 bushel per acre, double the county average. The second challenge is that current commodity prices are really tough. We're at a time right now in crop production where break even is maybe the goal this year. So it's always tough to try to implement any kind of price increase during a tough commodity time. The third factor we've identified, so you'll know that our leases do give the lessee the opportunity, if ever the board raises their lease rate, every lessee has 30 days to notify us that they don't wish to keep the lease at that rate. Unfortunately, this is a tough time of year to do that. They've already invested, the crop's been in, winter wheat was planted in September. Your inputs have been spent, the investment's been made. So it really doesn't give them the opportunity to opt out like our contract allows them. And the fourth and maybe most important factor is we haven't collected, there's a third of the data we haven't collected. We don't believe it's fair to put this requirement on those that did submit it when we haven't collected the final third yet. And there may be some question as to, if push comes to shove, can we force them to supply this? So that being said, the staff recommendation is simply to revert to the former practice of using county average yields until such time we are able to meet with the industry and lessees to communicate the issue further, explore other potential methods that may be out there for calculating our rents that directly correlates to the quality of the land other than yield. And the last item, we would consider an implementation method similar to past board decisions in grazing rates when the increase called for was more than, like, say, a 30% increase. We staggered it over several years, or it's been suggested maybe that we implement this new requirement upon renewal of every lease, so that a person is signing a lease in which they agree to supply yield data and can make that decision at least signing whether they are willing to live by those terms. Those are all things that we would investigate in the coming year, but in that time we would recommend that the board adopt the former method of using county averages.
So Matt, you're saying go back to voluntary submission?
No, Commissioner, I would go further to say to use the average for everyone. We shouldn't penalize, for instance, the guy I told you that voluntarily submitted it and doubled his own rent. He should actually get the average as well if we're going to live by the average for the next year.
So how, I'm sorry, I may have missed it for a sec. Yeah, so are we going to continue to use crop insurance data, or are we?
No, we would use the county averages, the county average yields.
Where do we get that data?
Now that is provided by USDA.
It is.
And in theory, it comes from all the crop insurance data they've collected at
Okay, so
USDA.
this, okay, thank you.
Which may raise for you the, sorry, it's Bill Ryan. May raise for you the question of why is the government's
Yes.
data so different from reality?
Right.
We don't have a good answer for that yet. So that's part of what we want to spend understanding here as well. I think we were stunned to learn that we were off by a factor of 2 sometimes.
Crazy.
And the good news is, turns out we've got some really productive farmland that the State Land Board owns when I see some of this yield data, but we've got to reconcile the situation.
Okay.
May I add that to the extent that our change in policy was going to cause large increases in rents for our customers, it's been the prior practice of this board to make sure we communicate that thoroughly and then stagger it over time. We've done that with our grazing rates where we knew there were going to be certain customers who had large increases. We tried to take them into account over 2 or 3 years. We did that with our oil and gas lease where we increased to a 20% rate, but we said, let's not do it until NIBR or oil prices are up to $50 a barrel. So we were trying to be good customer relations and good partners with the people who are important to us. So that element is in this recommendation as well.
Yeah, this is Assistant Director Massey. Will there still be an effort to collect the data even if rates aren't based on the data?
Certainly, we are going to encourage lessees. I just got more data in the last week that is still trickling in. So certainly, since it's anything they provide to us will go in the file and we'll collect the data.
It seems like that great opportunity to try to figure out why the county data is so out of line with what we're seeing on the ground.
You'd think even the legislature would be interested in reconciling those numbers.
You'd think.
You'd think. All right. Any further questions from the board?
Is there going to be, do you anticipate any blow? I mean, I think people will accept this, but there are those who did provide the information, paid potential, doubled their rent. Are we going to get any blowback for reverting?
I don't believe so. It's a very small number. I literally can think of 1 or 2 that were, and they're probably going to be glad to see their rent come back down to the average. So I don't believe there will be any pushback. There may be from, so the case of some of the lessees who submitted us yield data that's below the county average. I've got some that are Weld County, again, I'll use that example, 16, 17, when the county average is 24. They were anticipating a rent reduction. And to that effect, they may be slightly disappointed with this, but I don't think it'll be problematic. It's reverting to something we used for many years.
Yeah, this is Commissioner Butterworth. I guess my only somewhat of a concern is I thought that our process to get to the the current policy was thought out, and it was about there was a strong business case for that about what we're trying to do. I understand not biting everything, when someone's rent doubles, but and I understand there are other things at play here, but and I understand we're going to continue to have the conversation, but I mean, this is taking us not just a quarter step back, this is taking us back to 14 or 3 years effectively in our policies. And, it is what it is. I hate to say that, but, I did think that we arrived at a place that was a strong background, evidence-based case. So
I think the question I ask commissioners, are we willing to, that last third that we haven't collected, are we willing to threaten lease cancellation?
Right.
Or not threaten, are we willing to go to pursue lease cancellation if you don't submit it? That's a tough question.
You didn't, Greg Okish, Assistant Director, you did mention another option, which is we could go to a straight crop share, where instead of getting paid the cash equivalent, we simply take 1/4 of the crop. It's, in some ways, maybe it's more familiar with people. It raises the dilemma of then having the administrative challenge
Yeah,
of
right,
managing
right.
our 1/4 of the crop. But I think philosophically, we were trying to get to something where we were paid commensurate with the value of the land we were leasing. And so maybe in the spirit of your comment, we're still going to try to figure out how to get there. It just may take longer than we thought.
Anything else?
I will add, in our minds, we tied this to quality of the land, to the productive ability of the land. We did get a few complaints from producers that saw this as punitive to the guy that spends the money to raise his yield.
Right.
I don't buy that, because he still gets 75%, we get 25%. But that, just so you know, the argument we heard, that was part of it, is that we were somehow punishing the good producer. I saw it definitely tied to the quality of the land.
All right. Any further questions? Any public comment? Seeing none. Commissioners, anybody care to make a motion?
Can we simply move to accept the revised crop leasing policy as presented in the board packet?
That would suffice.
That sounds like a motion to me.
Yes.
Motion by Butterworth, second by Shaw. Further discussion? Seeing none. All those in favor?
Aye.
Chair is also in favor. Passes unanimously. We are out of time, looks like, yes. So I would entertain a motion to table. Oh, wait. Yes, we'll do a board leasing agenda, and then we'll table. Yep. We could, yep. Did anybody have any questions on the board leasing agenda?
No, I would move approval of the March 2018 board leasing agenda.
Second.
Motion by Butterworth, second by Carney. Further discussion? Seeing none, all those in favor?
Aye.
Chair is also in favor, passes unanimously. How about a motion to table item E, policy review 600-002, commercial leasing policy statewide, to our next meeting?
Is that okay?
Yes.
That's a motion?
Yeah.
Motion by Butterworth?
Can't you just table it?
I think you need a I don't know.
You're already there. Just go.
Yeah,
All right.
Give me a second.
Yeah.
Second by Carney. Motion by Butterworth, second by Carney. Further discussion? Seeing none, all those in favor?
Aye.
Aye. And the minutes, no changes to the minutes?
No.
All right. We are adjourned. Have fun, guys.